Good afternoon. The Appellate Division, First Department, is now in session. As a first order of business, I'm going to call the calendar. Please indicate your appearance, and then I will confirm to you the time that's been allotted for your argument. The first case is People versus Frascari.
Yes, good afternoon. Ronald Zapata for Appellant Dante Frascari.
Good afternoon. Beth Publin for the People.
Right, the time allotted for the argument is 3 and 1 for the appellant, 3 for the respondent.
Thank you.
Board of Managers versus Forenses. Mr. Corbett.
Sorry, Your Honor, I was on mute. This is Keith Corbett for the appellant of Harris Beach. Thank you, Your Honor. Good afternoon.
Thank you.
Meryl Sloan for CBS Realty.
Mr. Cornells.
Good afternoon, Your Honor. Grant Cornells of Warshaw Burstein LLP on behalf of Sahara Dreams LLC and other respondents.
Louis Krakow.
Good afternoon, Your Honor. Louis Krakow, Allegard Berger and Vogel for Kingdom Holding Company and Kingdom USA 22 Limited.
Thank you. All right, the appellant has been given 4 and 2. Each of the respondents separately have 3. Edwin P. versus Jenny P. is a submit. Butler versus Cruz.
Harlan Wittenstein for Appellant Butler.
All right, Mr. Wittenstein, you have 4 minutes.
Thank you, Judge.
De Palma versus De Palma.
Good afternoon. My name is Murray Scala of the firm Fader Kasovitz. The name that you see may not be my name because I'm using a colleague's computer. But again, I am Murray Scala and we represent the appellant.
Good afternoon. It's Greg Zucker on behalf of the respondent, Vincent De Palma.
All right, and the time allotted for the appellant is 5 and 2, and the cross appellant is likewise 5 and 2. Gerson versus Tax Tribunal.
Richard Levy of Sidley Austin on behalf of Gerson Lerman Group, the appellant.
Martin Nussbaum for New York City Tax Tribunal on behalf of respondent.
Right, appellant, you've been allotted 5 and 2, and the respondent 3 minutes. Hammer versus ACC Construction.
Good afternoon, Your Honor. Maribel Gomez from Gray and Gray for the appellant, Daniel Hammer.
Good afternoon, Your Honor. Nicholas Herzler for the ACC Defendants Appellants.
Good afternoon, Your Honor. Sim Shapiro from the law firm of Baxter, Smith & Shapiro on behalf of the defendant respondent, Premier Electric.
Good afternoon, Your Honor. Laura Matera from Nicoletti Spinner on behalf of respondent Godsell Construction.
Right, the appellant is granted 4 and 1. The cross appellant, ACC, 4 and 1. The remaining respondents are each granted 3 minutes apiece. Yang versus Dye, submitted. People versus Mohammed.
Good afternoon, Benjamin Rutkin-Becker on behalf of appellant Rashad Mohammed.
Good afternoon, Your Honor. On behalf of respondent, the Bronx District Attorney's Office, Catherine Reed.
Right, appellant, you have 3 and 1. Respondent, you have 3. Freiberg versus City of New York.
Good afternoon, Carolyn Canzanieri from Decolator Cohen and Prisco for the appellant, William Freiberg.
Good afternoon, Richard Lane from Marshall Dennehy for the respondent appellant.
And good afternoon, Your Honor, Eric Lee for the city.
All right, appellant, you have 5 and 2. Cross appellant Lasaga, you have 3 and 1. and the City of New York, you have 5. 219 West 81st versus New York State Division of Housing and Community Renewal.
Jeffrey Turkel of Rosenberg and Estes for the appellant.
Good afternoon, Your Honor. Anita Shah on behalf of Respondent, Division of Housing and Community Renewal.
And good afternoon, Your Honor. William Gribben on behalf of the Tenants Association, Respondent.
All right, appellant, you have 5 and 2. DHCR, you have 4, and the tenants have 3.
Thank you, Your Honor.
People versus O'Neill Watts.
Good afternoon, Your Honor. Allison Kale on behalf of the appellant, Mr. O'Neill Watts.
Good afternoon, Your Honor. Daniel Young of the Office of the Bronx District Attorney on behalf of Respondent.
All right, appellant, you have 3 and 1. Respondent, you have 3. Shaw versus 20 East 64th Street.
Good afternoon, Your Honor. Kenneth Roberts for the appellant's respondent.
Good afternoon, Vivian Turetsky for defendant respondent appellant 20 East.
Good afternoon, Eric Leiter for respondent Urban Foundation Engineering.
Good afternoon, Jonathan Schaub for respondent TriStar Construction Corporation.
All right, appellant, you have 6 and 2. Likewise, cross appellant, you have 6 and 2. Each of the other respondents have 3 apiece. South Shore Delights versus First Class Products.
For appellant Brett Berman from Fox Rothschild, good afternoon, Your Honor.
Good afternoon, Your Honor. Russell Morris for respondents.
Our appellants have 5 and 2. Respondents have 5. Caputo versus Stack, that's submitted. Gold versus New York Life Insurance is submitted. The first case on the calendar is People versus Frasqueri. You may proceed.
Thank you, Your Honor. Ronald Zapata for appellant Dante Frasqueri. Before I get into my excessive sentence argument, I wanted to address this court's decision on Thursday in People v. Aweka, which I believe should have been distributed to the.
It was distributed. So why don't you explain to us why you think that case is relevant?
Sure. Well, Aweka involved the newly enacted statute CPL 420.35-2A, and which permits waiver of surcharges and fees.
Correct.
I'm actually asking for something different here. I guess I'm trying to give you the background for why I'm asking for it here. But in Aweka, the New York County DA had consented to waiving the surcharges and fees, and the court waived them in the interest of justice. So I brought up this case to Bronx DA Copeland, and she informed me that the Bronx DA would be willing to possibly consent to the waiver of charges and fees, but they wanted to see the argument in writing first. And they've graciously consented to supplemental briefing on the issue. And so I talked to the motion clerk, and they said that this was the best way to bring it.
I don't understand what, I mean, it's not raised as an issue at all in your appeal. So how do we reach it?
Yes, that's why I'm asking this court if I can have permission to file supplemental papers based on this new issue, because I only became aware of it based on the Aweka decision.
Except that the defense bar had been otherwise raising this in other cases. But if the defendant is agreeing to, I mean, if the people are agreeing to it, then why do we have to otherwise be involved in it? Why don't you just submit a stipulation if you need an order on it?
Oh, the motion clerk said that because it was so soon before the argument that I should do it this way, because it would be, I guess, too soon to file papers or stipulation.
Well, I'm not going to contradict the clerk. I'm just a little loath to understand how we can otherwise add issues to the appeal at this point. But if you're agreed, then I think that might go far. It wasn't an appealed issue.
No, it wasn't, and this was my oversight, and I apologize, but I would hope
It's a question of oversight. It's a question of jurisdiction and preservation, honestly.
Well, I do believe when this court like when it allows supplemental briefing on a new issue, it would be permitted to reach that issue, especially when it's based on cases that are that occurred after the initial briefing.
Yeah, but the issue didn't occur after. The issue was alive because Awaka is not the only case that we had on this. All right, you know what? I'm going to give you an extra minute for argument because you haven't even reached the merits of the arguments that you do make in this case. So why don't you address that? I'll give you even though your time is up, I'll give you an additional minute.
I guess what was what was your official ruling in terms of the?
I haven't made a ruling, and quite frankly, I can't make the ruling myself anyway. We're a bench, we're a collaborative court.
Okay.
We're not gonna decide that right now. I think your best approach would be to submit a stipulation to us and see if you get it ordered.
Okay, so I guess I'll do that right
Not
after.
to contradict the clerks, but honestly, I otherwise don't see how we reach the issue.
Okay. So in terms of the excessive sentence argument, this court should reduce appellant's prison sentence to time served because of his young age. He was 19 years old at the time of the incident. This is his first felony, which is only a D nonviolent. He's never served any prison time before this case. And the sentencing court could have sentenced him to less than a year, but instead now Mr. Frescari.
Counsel, this is Justice Moulton. The defendant committed the crime that he pled to when he was 5 months into a young offender conviction for first-degree robbery. Is that correct?
Yes.
How should we weigh that?
Well, the prison sentence that should be imposed for someone so young, as the studies I presented show, that someone this young still that perhaps weighs in terms of giving a prison sentence, but in terms of what kind of sentence should be imposed, it should be the least restrictive possible. For someone who's never served prison time in their life, the court should have considered the least possible restrictive sentence, which would have been a definite sentence of less than a year.
Yeah, but in this case, Counselor, it was to a reduced charge, if I'm not mistaken, correct?
Yes.
So
However,
if it led to a reduced charge, the court really, its only discretion was either to accept the plea or not accept the plea. Could have made a suggestion, gee, I think you ought to agree to less time, but the court could not have independently have otherwise ordered a different sentence and the plea remained intact, correct?
Well, the sentencing court is not just a rubber stamp for the plea agreement. In People v. Farrar, the Court of Appeal stated that a plea bargain does not bind the court to impose a particular sentence that's imposed. And therefore, the sentencing court is not a rubber stamp. And if the sentencing court found that a lesser sentence was justified, then it should impose that, and the people likely would have gone along with it. But notwithstanding that, this court's jurisdiction under its interest of justice jurisdiction.
We have an interest of justice. We certainly do have that. You're way over your time, Mr. Zapata. Let's hear from the other side.
No, you have the wrong number. This is not Antonio.
This is
Beth Cublin for the Bronx District Attorney's Office. I apologize. I was actually kicked off initially. I hope that doesn't happen again. I just wanted to let the court know.
We saw.
Okay.
Yeah. This is just the reality of what we have to deal with in a virtual court.
Yes.
Let me ask you right off the bat, because I'm a little confused by your adversary wanting to kind of supplement the appeal now and put in this fee waiver. I mean, are you going to agree to that? I don't really understand how we reach that issue.
Regarding the fee waiver, yes, my adversary did reach out to me prior to argument. We are not at this juncture prepared to consent to the fee waiver itself. I conferenced this with my bureau chief, and we do need to review the papers. However, we will not oppose counsel's request for supplemental briefing if the court chooses to grant such supplemental briefing. And at that juncture, it's possible that if we agree that defendant meets the criteria, that we may consent, but purely in the matter due to prosecutorial discretion. However, at this juncture, we are simply not opposing counsel's request for supplemental briefing if the court chooses to grant him that.
I honestly have to say this is a first for me, but I will consult my bench.
And for me as well, Your Honor. With regard to the present case at hand, first review is precluded by the valid waiver of right to appeal, which was clear, thorough, and the court enunciated that the rights waived were separate and distinct. Moreover, with regard to the excessiveness of the sentence, there was already leniency here. Defendant committed the instant offense while he was less than 5 months into his probation for a youthful offender adjudication for robbery in the first degree. And even in this case, he was initially facing a top count of robbery in the first degree, a B violent felony with a determinate range of 5 to 25 years of incarceration. However, he was extended and availed himself of an extremely beneficial plea bargain by which he pled via Superior Court information to robbery in the third degree, a D nonviolent felony. And even there, the maximum was a 3 to 7 year indeterminate sentence, but he got the minimum statutory sentence, which was 1 to 3 years indeterminate. What counsel is requesting here is essentially a discretionary sentence below even the minimum statutory sentence. And for the reasons stated in my brief, defendant is not entitled to that relief. And the court should not grant additional leniency that when this defendant has already been shown leniency, not only in his prior youthful adjudication, but in this instant matter as well.
We're going to hear from Mr. Zapata on rebuttal. Go ahead, Mr. Zapata.
Thank you, Your Honor. I would just point out I would also mention all the issues going on with COVID right now, and one of my frustrations with the DA's office is that they had this initial position in that letter that I pointed out in my briefs that people who have state sentences of 6 months or less in prison and wouldn't be a risk to society should be released in terms for decarceration efforts. And now for them to be able to go about and actually implement these decarceration efforts, but not go about it is kind of frustrating on my part.
That's not a legal argument, though, Mr. Zapata.
Yes, Your Honor.
Okay,
well,
and I think the issue of okay.
And one of the things that they stated in their brief was how the docs has been able to minimize the risk. The numbers say otherwise. In December, there were 1,959 total positive tests in the corrections department. Their latest report says that the number of positive tests in state prisons has tripled since then. So their minimizing efforts are not working, and therefore the risks of getting COVID in state prisons are getting worse and worse. And it shows that
all right, we understand your argument. I'm not sure, how it applies to this particular defendant, but we'll figure that out. Okay, thank you.
Thank you.
The next case is Board of Managers versus Frances. You can proceed.
May it please the court, this is Keith Corbett of Harris Beach for the appellant, the residential board of the Plaza. As I'm sure your honors recognize, this case involves the storied Plaza Hotel on Fifth Avenue. Many years ago, about 15 years ago, it was broken up into different sections. Now the Plaza has a hotel component, a residential component, commercial entities, and so on. I represent the residential board. The main condominium board.
Counsel, may I ask you sort of a procedural preliminary question, which is, in this particular case, you did not, for some reason, choose to include the transcript from the oral argument that was held before the judge. I looked at all the orders that the judge wrote, and they really just said motion denied for the reasons stated on the record. So there's absolutely no way of figuring out what was the basis for her determination. And I think I tried to find it in scroll, and I don't think it's in scroll either. So it was raised by the various defendants by motion at some point earlier, I thought. But if not, I mean, you were aware that you did not have these transcripts in. Why would you not give us a complete record so we can make some kind of, intelligent valuation of what happened in the trial court?
Sure, Your Honor, we did believe we provided a full record based upon an 81-page complaint, the decisions and everything the court has. Those were just oral arguments. The decisions were issued by the court on multiple times. There was actually the court, when it was issuing its written decisions, if you look, they had to actually issue them 2 or 3 times. They kept having a lapse in connecting the right parties to the right action.
But she still said, I thought, I mean, the way I'm reading this, the judge said that the motion was granted or denied or dismissed in accordance with the court's oral decision following oral argument. So we don't have a copy of what the judge said. We just have the ultimate dismissed, granted, denied.
I believe you do have the original order of the court granting the Ellad's motion. And I believe you do have the subsequent orders which back up to that order. But just to be clear,
Counsel, this is Judge Owing. Judge Kapnick is saying, where's the transcript? We got all the orders. Where's the transcript? I couldn't find the transcript in the record on appeal. Is there a transcript?
The transcript was not in the record on appeal.
Why not?
The response we were told that we had a complete record on appeal based upon the orders, because this transcript was oral argument. There is a decision in there that lays out the judge's thinking for the first order.
You're missing the bigger picture. I am not disagreeing with you. I'm reading the gray sheets that the Supreme Court issued, and this is what Judge Kapnick is saying. It's relying on her oral decision dictated on the record. It says that, unless I'm reading it wrong, unless I'm reading totally different orders, so that in that regard, as Justice Kapnick is asking you, we need to see the backup to that. It's like you're filing tax returns. You need to have your W-2s when you file your tax return. You just can't say, "Oh, IRS, here's my tax return." Well, where's the W-2?
Your Honor, it's our position.
So do you have the transcripts or not? That's all. That's a simple question. Did you get the transcripts?
No, Your Honor, we do not have the transcripts.
Okay,
in the record.
that's it. I got my answer. Thank you.
Thank you. And I will just point out that no motion was made by the respondents, which would normally be the course, so that we could supplement the record. It was raised for the first time in the respondent's brief. Had we realized that there was a lapse, we would have immediately corrected it and put everything before the court. We do believe that based upon the record, totality of the record.
Counsel, this is Justice Moulton. Your opponents cite Nathanson and Seberg, I think is the other case, both of which are fairly clear that you should attach a transcript as part of the record. You don't even cite those cases or try to distinguish them.
We actually do cite the cases in our reply brief that specifically pull out why we believe it'd be kind of draconian not to hear this case. We have a voluminous.
Well, all right, this is Judge Gish. When you let's assume the best, that you found out that they thought that your record was defective when you got the brief. Why didn't you make a motion at that time to supplement the record so that we wouldn't have to deal with this issue?
I understand, Your Honor. We did speak with the court at that time, and they advised that since briefs were already filed, the best way to handle it was to put forth in our reply
again,
brief.
I hate to say, I hate to disagree with the clerks, but on the other hand, it was your advocacy. You can't rely on them for legal advice. I don't think that's fair. And you made your decision. So maybe it's significant, maybe it's not. It's just puzzling to us. Okay.
Your Honor,
all right. Your time is up. Let's hear from, we're gonna hear from Ms. Biscone on CPS 1.
Good afternoon, Beryl Biscone for the respondent CPS. Initially, I'd just like to point out, Mr. Corbett indicates that he didn't have the transcripts, but in fact, he cites to it in his brief, page 14 and 16. So he does make reference to the transcript. So I believe he does have the transcript. And it's our position.
Were you able to get the transcripts? Do they exist?
They do exist, yes.
Sure, the court made its decision on the record.
Yes.
They exist. Okay.
Right. And it's our position that the entire appeal should be dismissed on this procedural ground, because once we pointed out that it wasn't included in the record, he had a duty to include it for this court's review so the court can see exactly the reasons behind the judge's decision. Turning to the merits, it's also our position that it was very disingenuous for the plaintiff not to mention the settlement agreement anywhere in his brief. The third, fourth, and fifth clauses of action that the lower court found was outside the settlement agreement. It's our position those were properly dismissed.
But counsel, didn't the settlement agreement, and for that matter, the release that was signed, have kind of a carve out for claims relating to the electricity?
Right. So there were two specific carve outs that he does speak about with his other causes of action. But just in terms of background and for this court to know how procedurally this case happened to be, we think it was important for the settlement agreement to be mentioned somewhere. But be that as it may, the other causes.
Well, we know about it.
Yes, well, because I made reference to it in my brief, otherwise the court would not. The causes of action based on alter ego allegations, it's our position they were properly dismissed. The plaintiff did not listen to the trial court. They didn't offer any more detailed allegations in the second complaint than they did in the first complaint. They continue to offer vague, conclusory, alter ego assertions of liability with no backup. Plaintiff continues to lump all the defendants together, concludes that they're alter egos without any factual basis. Plaintiff's unspecified claims that all the sponsored defendants should somehow be accountable altogether without any specific factual allegations. For all of these reasons, it's our position that the trial court properly dismissed these allegations. And finally, as to the 20th cause of action, they were dismissed as to all defendants except for the sponsor. And it's our position it was properly dismissed as to the sponsor too, because the specific carve out of the sponsor was not alleged in the second amended complaint. So for those reasons, it's our position that if the appeal is not dismissed, that it should be affirmed in all respects. Thank you.
All right, now let's hear from defendant Sahara Dreams.
Good afternoon, Your Honors. Grant Cornells. I represent 16 respondents in this case who, for lack of a better term, are referred to in our brief as the Sahara respondents and the other respondents. We incorporate and adopt all of the arguments presented by the counsel who represent the other respondents in this case. The four Sahara respondents are the same four entities that are defined in the complaint as the Sahara entities, and they are subject to the same impermissible group pleading allegations that permeate the second amended complaint. The other group of 12 defendants, there are no substantive allegations made about them whatsoever in the second amended complaint, whether it's a group of defendants or otherwise. So I think by any standard of review, the second amended complaint fails to state a cause of action against any one of my clients. The complaint doesn't satisfy even the most basic notice pleading requirements of CPLR 3013. It doesn't state a cause of action pursuant to 3211A7. And it certainly does not plead with particularity under CPLR 3016 for those causes of action, which would require that.
Did your clients have anything to do with the installation or maintenance of the meters, these electric meters, which is what I think this case is mostly about?
No, the renovation, the construction, the installation was handled by the sponsor of the building. My client acquired the 3 non-residential condominium units in December 2012. They are not a sponsor, not a successor sponsor. They did not inherit any of the obligations or duties of the original sponsor.
Thank you.
The deficiencies in the complaint are not remedied by the presence of alter ego allegations, which are every bit as conclusory as the other allegations in the complaint. We agree that the appellate's conduct in this case has been frivolous and unprofessional, as evidenced by the fact that the appellant, in bad faith, sued numerous parties that have no connection whatsoever to the condominium or to any of the issues in the case, some of which do not even exist, all of which we pointed out to appellate's counsel before they filed their second amended complaint. And that's in a letter that's at pages 1233 and 1234 of the record. Appellant also repeated verbatim the same alter ego allegations that the IAS court found lacking when they were made in the first amended complaint.
And was that first amended complaint was dismissed? Many of the causes of action were dismissed at that point. Is that correct?
Yes, the only party that moved against the only parties that moved against the first amended complaint were the what have been referred to as the allied defendants.
Right.
And the complaint was indeed dismissed.
All right, we'll hear from the next respondent, Kingdom Holding respondent.
Thank you, Your Honors.
Thank you.
Thank you, Your Honor. Louis A. Craco Jr. for Kingdom Holding Companies and Kingdom 22 USA Limited. I join in all of the arguments that have been made by my co-counsel with respect to the inadequacy of the pleadings. They don't satisfy basic notice requirements under CPLR 3013. They don't even approach satisfying the particularity requirements of which at least 8 of the causes of action in the complaint apply. And I also join in their argument, which Judge Kennedy clearly embraced, that they have not remotely satisfied their pleading obligations to demonstrate that any of these entities, including my clients, are alter egos of each other such that their corporate separateness ought to be disregarded. With respect to that last point, I would just add one that is specific to my clients. The law of New York is well settled that when considering a request to pierce a business entity's corporate veil, we look to the substantive law of the jurisdiction of organization of that entity. In this case, Kingdom Holding Companies is a joint stock company organized under the law of Saudi Arabia. Therefore, it incumbent on plaintiffs to show that Saudi Arabian law would justify veil piercing under these circumstances. They failed entirely to do that. In the record, there is an affidavit by a distinguished Saudi and American lawyer by the name of Al-Sudari. It appears in the record at pages 1280 to 83. And Mr. Sudari expresses the opinion that nothing in Saudi jurisprudence remotely
not too much veil piercing allowed in Saudi Arabia, is there?
No, Your Honor. There is
what the lawyer said.
Corporate or otherwise, Your Honor. And
right, that's what I understood.
So they have the appellants have not even attempted to address, let alone rebut, that showing. Similarly, Kingdom 22 USA is a Delaware corporation. They haven't addressed Delaware precedent or Delaware standards for veil piercing. Finally, Your Honor, I would simply refer to the second cause of action. Because they can't direct liability under 3013 or 3016, and because their efforts to pierce the various defendants' corporate veils are so inadequate, they have included a second cause of action which attempts to tie them all together through a conspiracy theory. The problem is, in order at New York law for you to make out a cause of action for civil conspiracy, you have first to competently plead an underlying tort.
An underlying tort. Yeah, we're aware.
And they've utterly failed to do that. So with that, Your Honor, we'll rest on our briefs. Thank you.
Okay, rebuttal. Mr. Corbett?
You're on mute.
Unmute yourself, please.
Thank you, Your Honor. Your Honor, I mean, we'll make it happen. If it would assist the court to put in a transcript, we would obviously submit a transcript to the court. But Your Honor, if I may.
I'm not giving you permission to do that. You're
I
a very
understand.
experienced law firm. You made your decision. I don't know whether that's going to impact or not, but, you know, we're certainly not holding this appeal open for you to remake a record that you should have made that after we've done all the work and considered what you put in front of us.
I understand, Your Honor. Thank you. Just to the merits of this case, I mean, this is not a situation where you have really a piercing of the corporate veil. You have, and though it's been briefed before the court, you have three entities, Sahara, Al-Ad, and Kingdom, who all have business interest in the plaza, whether it be running the hotel, running the Oak Room, dealing with commercial entities. It is undisputed that an auditor and law firm hired by those respondents overcharged my client $3.7 million. That's $3.7 million that those three separate entities and their subsidiaries should have paid towards electricity costs. There's been a lot said about this alter ego, and it's been briefed fully for the court, and I know the court's read the briefs, but this is not a simple situation where you're trying to get to the subsidiary or to the mothership of the subsidiary. What happened here is you have three other entities who all have collective joint business interests, and they didn't pay their fair share of the electricity cost of the $3.7 million. As it relates to the settlement agreement was briefed in our reply brief. We don't believe it's germane to this case at all, in that there was a specific, clear carve-out in the settlement agreement that specifically states that my client can still go after the respondents for electricity charges that they were overcharged. It's a specific carve-out in the settlement agreement that does not bar the bringing of these claims. We believe that in the 3 volumes of the record before the court, with all the documents, we put a full record before the court, the decision could be made, and we're asking for the reversal of the lower court. This is a pre-motion answer to dismiss. 81 pages, 13 of those pages are nothing but straight facts. 13 consecutive pages of facts, which are then used in 21 causes of action. We believe within the 4 corners of this agreement, this is a sufficiently particular complaint that at least entitles our client to discovery.
We're aware of the standard. Thank you, Mr. Corbett. Thank you all. The next case, Butler versus Cruz.
All right. Good afternoon, Your Honor. Harlan Wittenstein for Mr. Butler. It's my position in this case that the lower court judge erred by failing to consider the uncertified copy of the police report that we submitted into evidence in support of our summary judgment motion. I believe that I laid a proper foundation as an exception to the best evidence rule to get this report into evidence. The first thing I did was I went to the website for the Department of Motor Vehicles. There was no listing of this police report.
Counsel, this is Judge Owen, but that report that you're talking about, that police report, that came in on reply, correct?
Yes, but
why put it in your motion in chief?
Well, I made a prima facie case without the report, Judge. I didn't anticipate the defendant to lie in his affidavit in opposition.
Okay, well, you got to anticipate everything. You know, that's what we're trained lawyers to do, right? I mean,
well, Judge, this is not the first time I've done it also, because this usually the defendant just either tells the truth or just argues it's premature. But in this case, under the case law, if I made a prima facie case without the police report, my papers were satisfactory, and they were. In fact, the lower court judge ruled that I did make a prima facie case. The question was whether or not a question of fact arose by the evidence by the defendant. The defendant then submitted an affidavit which contradicted the statement made to the police. I submitted the police report to show the judge that what statement was made at the scene, and then I laid a foundation in my argument.
Counsel.
Yes.
That might be grist for cross-examination, the contradictory statements of Mr. Cruz, but doesn't his affidavit defeat your motion?
No, because he attempted to raise a feigned issue of fact. Judge,
well,
if
that
statement.
Go ahead.
All right. The statement in the police report was hearsay, right?
Well, it's a prior inconsistent. It's an exception to the
report.
Hearsay rule.
It may or may not be if you can otherwise authenticate it as belonging to him.
Yes.
But usually when we talk about feigned issues of fact, what we're doing is we're sort of comparing a statement made in a deposition during the course of a lawsuit to a new affidavit that takes a contrary position. This is, even if we assume that this hearsay statement was in fact accurately transcribed by the police officer, then again, I'm going to reiterate my colleague's question to you. Why isn't this just a question of credibility that would otherwise go to the finder of fact?
Well,
goes to wait.
Well, for one thing, in the case of Thompson versus Coca-Cola that this court decided back in 2019, the facts were almost identical. The plaintiff submitted the police report. The defendant offered an affidavit which contradicted the statement made in the police report, and this court ruled that the statement made to the police report in the police report was admissible. It was an exception to the hearsay rule. It was a prior inconsistent statement. It was an admission by the defendant. It's almost the same case.
In that case, though, the problem is the plaintiff put the police report in the moving papers.
But it was also an uncertified report, Your Honor.
I'm just saying that there was in the motion in chief the uncertified report. That's all I'm saying.
I understand, but in my
reading, better if you had that. If you had that in your motion in brief, you wouldn't be having this argument.
But I presume the lower court judge would have still said it was hearsay because it was uncertified.
No, but then you'd have a better appellate argument.
Wait a minute. Being uncertified doesn't make it that doesn't make it hearsay. It's hearsay because it's the statement of a defendant that is recorded by the police officer. That's classic Johnson v. Lutz.
Well, it's my understanding also, Judge.
That is hearsay.
Well,
okay.
Judge, it's my understanding the report itself is hearsay. The certification.
Well, the certification is a different issue, but we're talking about something other than the certification.
Yeah.
We're looking beyond the certification problem. Honestly, our questions on argument are giving you the benefit of the doubt that they're right on best evidence or whatever.
Yes.
I don't know why it wasn't filed with Albany, but whatever.
Okay.
But we're asking you, does it still pose a problem for you?
No, it doesn't.
And that's that. Well, I know that's your position, and that's what we've been asking you. Okay.
Well, Your Honor, it's my position. Yeah, it's my position that
I sat. Time and you're the only one arguing here. So we're gonna consider the arguments in the briefs, which we have, and we'll come to a decision. Thank you very much.
Thank you.
De Palma versus De Palma.
Good afternoon, Your Honors. My name is Murray Scullig, and the name that you're seeing is not my name.
It is your name, actually. We see it. Go ahead.
Great. In this case,
we did before change.
No, I don't.
Now we don't. Now you're Scott. All right. That's all right. Go ahead.
In this case, plaintiff's complaint alleges that the defendant husband stole $10 million from her. He did this by making false representations about what he owned in the party's matrimonial settlement agreement and in his net worth statement. He swore and represented in the settlement agreement and net worth statement that at the time of the settlement, he owned A. In fact, he did not own A, he owned B. Specifically, he swore and expressly represented that he owned special shares, common shares, and options in an entity known as Shredded, and expressly swore.
But counsel, I'm sorry to interrupt you. The wife knew of the merger and didn't pursue discovery concerning the husband's new position in the new company.
The merger is entirely irrelevant to this case. This is a case about a misrepresentation of an asset that someone owns. The law, the matrimonial court rules, the domestic relations law, and well-settled principles of matrimonial law and contract law do not exculpate a contracting party from lying about his express representations. That's exactly what happened here. The merger is a distraction. It has nothing to do with it.
Well, the merger gave rise to the assets. That's why else might have gone off.
That is not the case. We are faced with a representation in clear and unequivocal language where the husband swears that at the time of the settlement, he owns certain securities and swears that there has not been an exchange and transfer of those securities, I submit to you respectfully that no further discovery was necessary. That representation is all that was needed. And every contract case that contains an express representation provides that you're not relieved from your representations because of your education or because you could have taken more discovery or because you learned other facts. You are bound by your representation. That is Hornbook, textbook, contract law. The error of the court below was that the judge failed to appreciate that this was a breach of contract cause of action. It was not about discovery. What the wife's education was, or what she might have learned or might not have learned, did not relieve the husband.
Well, your remedy wasn't really for breach of contract. You weren't looking to get what you didn't get under the contract. Your claim was that what you agreed to under the contract should be disregarded because there was fraud, correct? I mean, because she got what she was entitled to under the contract. Aside from
she accepted a payment for 50% of A, which the husband did not own. He did not own A at the time.
But you know what? He owned it at the commencement of the action.
Irrelevant.
Right?
Irrelevant.
I don't think it is irrelevant. Well, because there was a valuation of that asset. There was discussion about the fact that it may be subject to a merger, which may change value. In fact, the neutral expert, in fact, said that. In general, we have active assets. Matrimonials are largely valued based on a date of commencement. She agreed to the date of commencement. No, I honestly, I don't understand how you could say it's just a breach of contract. It's not just a breach of contract because if there was, there would be no damages for that representation. You're claiming that she shouldn't be held to the agreement because of that representation. You want out of this agreement. You want a piece of the valuation of the merger. So to say that the merger is irrelevant is actually mind-boggling to me. Go ahead, answer.
I must, with all due respect.
I'm respected. Go ahead, respond to me.
Your statement.
I'm respected. Respond.
Your statement is incorrect in multiple respects. Number one, the date of valuation has not been determined, was never determined. Our position was that it was a passive asset, and at the trial, we had every right to establish.
So if it was a passive asset, then why didn't you elect to have it valued closer to the trial date, post-merger?
We were not.
You didn't. You didn't have that. The information wasn't even available to put in the record.
We were never foreclosed from establishing the value of those assets had we known what the assets were.
But that's not breach of contract. That's your claiming you want out of the contract. You want a different contract.
That is classic New York Court of Appeals cases. An express representation was made. That representation was untrue. It's nothing. It has nothing to do with the merger. It has nothing to do with valuation. Our complaint stated multiple valid causes of action.
All right, I think we understand your argument. And my colleagues have any questions? And let's hear from your adversary. You'll have time on rebuttal.
Thank you, Your Honor. My name is Greg Zucker, and I represent the respondent, Vincent De Palma. This is a case where at the time that Carol De Palma entered into the settlement agreement, she knew about the shredded syntax transaction, she knew that there was a newly formed entity, and she knew that my client's interest was in that newly formed entity. Separate from all the cases that he cites, there's not a case where this issue of the transaction was addressed and discussed with the lower court before the settlement agreement was entered into. The documentary evidence is unequivocal. In the malpractice case, Mr. Scala indicated to Judge Pauly she knew about the merger early on. The November 7th, 2014 letter to the court is dispositive.
Mr. Zucker, why does Mr. Scala say that this has absolutely nothing to do with the merger?
It has everything to do with it, Your Honor. On November 7th, 2014, they wrote a letter to the court They wanted the court to weigh in, and they requested a conference. They wrote, the major issue is shredded, and I quote here, shredded combined with a document destruction business, Synthesis Corp, to create a newly formed company, a combined company. They knew that Vincent's interest was in that combined company. Rather than making a formal motion, rather than appealing, and rather than trying the case, they decided to settle with their eyes wide open. In the settlement agreement, they acknowledged they had all the information they needed. They waived the right to further disclosure, documents, depositions, a forensic, and they waived any and all claims, known and unknown, present, past, and future. What
So
did they do
is
after?
is that the entity known as Boost?
It is, Your Honor.
And that's what where the $20 million came out later, that he got $20 million from the payment of Boost?
Not exactly, Your Honor. The newly formed company was Boost. After the settlement agreement occurred in 2015, this company Boost explored an IPO. It was unsuccessful, and they later sold to a company called Stericycle for lots of money. Carol DePalma is seeking to undo everything so she could get a portion of the lots of money. There's a disdain for doing that. There's finality in matrimonial agreements, especially when you have someone here experienced. She had a degree in finance, an MBA from Wharton. She had lawyers, and she made a conscious decision to do this.
So
And
if her motion, if she had decided to make a motion below, which I understand she didn't, she made a letter request to the judge. The judge didn't allow any other discovery, and she did not pursue it by a motion. Would there have been any way for her to have learned about the situation with Boost and what was happening there?
Your Honor, the way it occurred is that Boost was a publicly disclosed transaction in March of 2014. They indicated they knew about it early on, and what occurred was when we served our disclosures on November 4th, 2014, which was the statement of net worth and the disposition of assets, they were exactly like the prior disclosures, that everything was based upon the commencement date. Because she received those November 4th disclosures, that's why I believe that her lawyer made a November 7th application. And as far as the commencement date, the parties had chartered a course that they were using the commencement date as the valuation date. The Weckler case is directly on point. KLG's retainer said it. Both KLG reports said it. And Mr. Scala said it in the context of his motion to dismiss the memorandum in opposition to malpractice. He wrote, litigation ensued for over a year, during which time period Carol's lawyer simply acquiesced in using the commencement date, the record at 473.
Yeah, I know you say they acquiesced, but there was no ruling from the judge about what date the asset was going to be valued, was there?
There was not a ruling from the judge. There was only...
And in fact, there was no written stipulation agreeing to that date.
That's correct too, Your Honor. All there was
The common convention, though, is that an active asset like this, he was CEO of the company, it's an active asset, that it's valued as of the date of the commencement of the matrimonial action.
That's right. And that's why Jeff Schechter, who represented Vincent DePalma, opposed the application. He said that, one, it was the eve of trial, two, the case had been certified, and three, because he had left the home in Long Island and went to Canada 3 years before the matrimonial started, this was an active asset where he was the CEO and president, and therefore, even if there was an appreciation in value, she wasn't entitled to it. The cases we cited are directly on point. You have a case called Etzion, Second Department, a 3211A1 decision. And there what happened was the husband represented that as of a memorandum, there had been no offers or deals. It turns out that that property had been valued by the neutral at $6.5 million. In reality, it sold for $84.5 million, $78 million more. And in that case, it wasn't rescinded or reformed. I have a better case, respectfully, because in this case, Carol knew about it beforehand.
Okay, thank you. We're going to hear from your adversary on rebuttal.
I'll speak quickly. You are assuming, or your statement presupposes many incorrect findings. This is not an active asset. It's a passive asset. Mr. DePalma owned 1% of the company that was sold for $2.3 billion. So that, at worst, it's a factual issue. Ms. DePalma never waived the truthfulness of her husband as to what he represented he owned. The fact that
Shredded, which was owned during marriage, before the marriage pod closed, was an active asset.
It was not. It was a passive asset.
Shred it?
It was a passive asset. It was a multi-billion
He
dollar.
was the CEO.
He was a CEO of a multi-billion dollar corporation. He had minority control. He didn't control the board of directors. This wasn't a corner grocery store that he controlled. This was a multi-billion dollar company. To say that it wasn't it was a passive asset. And again, at worst, it's an issue of fact, but don't accept as a matter of law that it was an active asset. That issue has to be tried. Furthermore, Ms. De Palma.
Wouldn't it have been tried in the matrimonial action?
That's
wasn't
correct.
that the time to try it?
She decided not to try it because, like the multitude of corporate transactions that preceded this merger, the husband swore under penalties of perjury and an agreement that he owned special shares, common shares, and options. He lied. And the reason he lied is he got away with $20 million. And for the case to be dismissed on the basis of some collateral issue, a fact-driven issue as to whether or not there was a merger or not a merger, why would he have told the truth beyond a sworn net worth statement? That's exactly what sworn net worth statements are supposed to do. People sign them under perjury. He lied. He doesn't say he doesn't lie. How can you exculpate someone who lies about something as basic as what he owns? There is no case in this jurisdiction that exculpates or exonerates a husband or a spouse that lies about what he owns.
Right, we
That's what
understand
this
your
case
argument.
is about.
Your time is way over, Mr. Scala. Forgive me for cutting you off. I've been cutting everybody off today. Mr. Zucker, you have 2 minutes, and I'm going to hold you to it strictly.
Got it. Just a real quick point. For 4.5 years, she ratified this deal. He paid $3.96 million, and she accepted $3.75 million, 95%. And to the point that was raised before, yes, in a release, if a person's not paying, there's usually an exception. Here, he paid every single dollar. And the only reference to Vincent's interest as of the May 29, 2013 date and the KLG reports is because the parties agreed and accepted that valuation for the purposes of settlement. Thank you, Your Honor.
Okay, thank you both.
May I have one remark?
No, you may not.
Thank you, Your Honor.
Thank you. Hammer versus ACC Construction.
I think you skipped Gerson, Judge.
Did I? You're right, I did.
I'm sorry. I'm
No,
sorry.
thank you. Thank you. Thank you, Judge Kapnick. Gerson. Gerson versus Tax Tribunal.
Counsel, you're on mute. Mr. Levy, if you're speaking, you're on mute.
Thank you. Are you able to hear me now?
Yes, now you're off mute.
Thank you. May it please the court, Richard Levy of Sidley Austin for petitioner Gerson Lerman Group. In 2005, petitioner identified an error in its tax returns. It had made a mistake in the apportionment of its New York City and New York State taxable income. It filed refund claims for 2003 and 2004. It corrected its methodology on a going forward basis for all years thereafter. New York State paid the refunds. New York State audited and accepted the returns which were filed on a different basis. And nearly 16 years later, we're still fighting with New York City to have New York City apply the statute and the regulation, which are clear on their face according to their terms. There's only one issue here. And that one issue is how much of petitioner's income is New York City able to tax? New York City applies a 3-factor apportionment formula. It looks to payroll in the city versus payroll everywhere, property in the city versus property everywhere, and receipts in the city relative to receipts everywhere. There's no dispute as to the payroll or the property. There is a dispute as to the receipts factor, and the receipts factor measure is, for our purposes, as a service provider, a question of where the services were performed. Petitioner and respondent don't disagree that there is a service rule application here. No one disagrees that—
Counsel, in determining the receipt factor, you put all your eggs in one basket or in 2 baskets, council members and research managers, correct?
Yes, Your Honor.
What about the whole infrastructure of the three other categories that support those people? It seems like it's a very hierarchic view of how receipts are generated, that you have only these rainmakers and then none of the support staff get any credit for the money they create.
Your Honor, I'll analogize it to a law firm. In a law firm, you've got billers and you've got non-billers. When you look to how services are performed, you look to the partners, the associates.
You use that analogy in your brief, counsel, and I don't find it that persuasive because the billing amounts that the partners charge and the associates charge include amounts that they need to pay their overhead. So,
absolutely, Your Honor. But all the other classes of workers that you're referring to, whether they be salespeople, computer engineers, accountants, recruiters, all those other people are captured in the payroll factor. They're already accounted for. What the city is trying to do is double count those people and include them in the receipts factor. So the statute very clearly says, where were the services performed? To be able to answer that question, you have to identify what the services are, which are very clearly under the contracts, under all the schedules, under the undisputed testimony, oral consulting, custom written research reports, and meetings, seminars, roundtables, and other events. And the only people who are performing those services, which is what the statute and the regulation both look to, the only people who are doing that are the independent contractor council members, the consultants themselves, and the research managers who help to identify the expertise needed amongst the population of consultants, who help refine the expertise needed, who help form the questions, who organize the events, who edit and draft the written research reports, who curate the meetings and seminars. Again, the statute says, look to who is performing the services. The services are performed by the consultants. The services are performed by the research managers. Recruiters who...
So, Mr. Levy, this is Judge Gish. Just a question. You know, we get these proceedings and we are supposed to look at them with a deferential eye to the agency, to the tax tribunal. And even if we understand your point of view, why is it something that would be appropriate to look beyond what the agency did, that the agency was unreasonable in what they did?
So, Your Honor, there are really two standards which potentially apply here. I think the first and foremost, we've got very clear statutory language, and I believe that the administrative law judge of the Tax Appeals Tribunal correctly read and applied the statute according to its terms. To say that a salesperson who is securing contracts to provide services and renewals for contracts to provide services and being a cheerleader to encourage the client to use the services more so that they will renew their subscriptions, to suggest that is within the definition of performed the consulting services, that's facially wrong as a matter of law. And frankly, even if we were to say that there is a very, very broad definition of performance, that performance, includes all these other indirect contributors. If you look to the undisputed testimony in an almost 2,400 page transcript, 10 witnesses, including the consultants, including the research managers, the salespeople, the back office people, all of these people, it is very, very clear that the most a salesperson could possibly be accused of doing is receiving a complaint every month or two and forwarding it on to someone else to address. These people aren't performing the services. These people are contributing to the operation of the business. The point is that the statute doesn't say, look to the overall cost of performance for operation of the business. There is a different statutory standard in the same provision of apportionment that says for other business receipts for which there isn't a specific rule, you look to where the receipts are earned. And the city from day one has been trying to characterize what Gerson-Lerman does, not as the provision of services because they don't like the where performed rule, They've been trying to say that this is a subscription. These are intangible rights. These are contract rights.
Right.
That this is something more.
That's how they look at it. All right, let's hear from your adversary, Mr. Levy, because you're over your time.
Thank you.
Martin Nussbaum for New York City. I just want to touch on a few points. The rules of construction for statutes and regs, what the services are, because we have a disagreement as to what the services were, and the facts. We touched already, I heard the standard of review for the decision below. It's substantial evidence. The appellant must show not only that it has a plausible interpretation, but that its interpretation is the only rational one. And they failed to do this.
Mr. Nussbaum, counsel is arguing that this is a very clear statute as to where the service is performed, and certainly couldn't include those other people. So that he feels that your interpretation, the tax tribunal's interpretation, is actually not rational because it's clear the other way. That's at least what I heard him say.
That's because he's viewing the services as merely the end product. We disagree. The appellant offers a lot more. Gerson offers a lot more than mere consultant opinions. Indeed, the appellant itself defined its own services in its contracts. Its customer contracts say Gerson helps clients find, engage, and manage experts. It's not just the end opinion. The appellant distinguishes itself from its competition, like a McKinsey or Baines, through a broad package of services, a knowledge and logistics platform, research databases, convenient access to multiple opinions, and matching all the conflicts.
Excuse me, I'm sorry to interrupt you. What about counsel's argument, if I thought I heard him correctly, that the participation of these other people is captured in other categories and shouldn't be put into this category, that it's already been captured, they've already gotten their tax on that. It's sort of like they're getting a double recovery.
There are other employees who are in the payroll factor, but these are the people who are performing the services. So even if there's some overlap, we don't feel that that's a fatal distinction. We start with the rule of construction.
Let me just stop you there. Is it customary for a category of employee or people in an organization to show up both in the payroll category and in the services category? Is that common?
It is not common, but these facts are unique. The salespeople here, the salespeople of Gerson's have ongoing and continuing responsibilities, even after securing the subscription, to help clients optimize usage and suggest consultants. They actively
I understand based on the services, but the problem is he raises a double dipping issue. Right. And I'm just saying, for purposes of the formula, would you concede the point that these people shouldn't show up in two places, that's a double counting, or is that irrelevant?
The regulation, the statute says services by whoever performed, whether employees, independent contractors, subcontractors, or otherwise. That is broad language. Now, the tribunal's holding is applying the rule of construction. Exemptions and deductions are strictly construed in favor of the taxing authority. The same rule of construction applies to allocation issues. So the rule of construction is in favor of the taxing authority for allocation issues. The language of the reg is broad, and the tribunal was rational in interpreting that way. So the appellant, I already told you what the appellant defines in its contracts. They distinguish themselves on the basis of all of these other team efforts. The facts show a team effort.
So then the regs themselves don't prohibit a double counting?
No, they don't.
Okay.
There's no specific definition saying if services were already encompassed in the payroll, they can't be in the receipts factor. There's nothing like that, or in the case law that I'm aware of to that effect. Going back to the team effort, the 5 categories of employees render the service. The infrastructure, the database, the sourcing tools were all critical part. And especially in the main category of customers that petitioner has, that appellant has, they have a lot of investment managers as clients. Time is money. Nanoseconds are money. The facts show the scope of the search services available via the website actually increased with higher subscription levels. So the platform saves time, streamlines the search for opinions. In the split-second world of investment management, time is money. The appellant CEO stated under oath, our model is different. Why? Because of the service we provide as a team and because of the way we provide it. So if a customer is coming to them because of this team approach, as opposed to going to McKinsey, we have to take that into consideration. These facts are unique. The
I'm
rationale.
going to ask you to wrap up your argument because you're over time.
Oh, okay. Well, I'll just say simply the tribunal was completely rational in its finding. The appellant's clients each receive a unique service tailored to their specific needs. It's more than the conversations, the seminars, and the written information. The council, those are merely the end product of the work, and I think the statute is not that restrictive. The facts in the record support and provide substantial evidence supporting the tribunal's conclusion that each category identified by the tribunal was performing an integral component of the services rendered.
Thank you. All right, Mr. Levy, your rebuttal.
Nobody ever pays to be sold to. If I go to buy a fancy watch, a motor car, a motorcycle, whatever it is, the sourcing rules are absolutely unconcerned with where the salespeople are. They are unconcerned with where the labor behind what's being sold is performed. Whether we're looking at services, sales of tangible personal property, licenses, and other intangibles, the rules have a very specific formula, which is you count the labor which is used to produce, to operate the business based on the entire payroll. You look at the property of the company, and all of that property is counted. But for services, you look not to the overall expenditure of effort. You look to the performance of the services. It doesn't matter whether it's plumbing, carpentry, engineering, architecture, law, or consulting services. The only thing that the statute is concerned with is where were the services that were paid for performed? Oral consulting, written research, meetings and seminars, the consultants which are providing these services, the council members and the research managers are what is being paid for. Obviously, petitioner here, just like any other taxpayer, any other commercial enterprise, is going to try and distinguish its services from the others, say why it's better, and engage in puffery and salesmanship and say we're better because. But at the end of the day, what is being purchased is consulting services. And if someone is not performing consulting services, neither the statute nor the regulation contemplate their inclusion in the receipts factor. Salespeople are seeking renewals, they are seeking new contracts, and they are cheerleading for the usage. The council managers who recruit the people to be able to consult, obviously these people are very important, but they're not performing the services. And that's what the statute calls for, and that's what the regulation calls for. And while these are obviously well-compensated people, otherwise and important to the business, otherwise the company wouldn't employ them and wouldn't pay them salary and benefits, they are not the people who are performing the services. And that's what the statute calls for.
Thank you. Thank you both.
You're welcome.
Okay, now Hammer versus ACC Construction.
Thank you, Your Honor. And may it please the court, Maribel Gomez for the appellant Daniel Hammer. With respect to plaintiff's labor law 200 and common negligence claims, the lower court completely ignored several key pieces of evidence in the record which prevent respondent from making a prima facie showing as to their lack of notice.
Can I ask you, are you going under the 200 claim? Are you going with a defective premises or with means and methods or both? Because obviously,
Your Honor, this case clearly falls within a defect on the premises fact pattern. It's undisputed that what caused the plaintiff's accident was a trench in the floor with conduit in it and wires coming out of the conduit. Plaintiff concedes that what caused plaintiff's fall were those wires that were in the conduit. So it is a defect in the premises. And with respect to that defect and actual notice, respondent's own witness prevents them from proving their entitlement to summary judgment. Respondent argues that the condition that the ACC superintendent saw before the happening of the accident didn't include the loop of wires that caused plaintiff's fall. However, this witness's testimony puts that in issue at page 673 of the record. There, Mr. Hubert, who is the witness, the ACC superintendent, is asked if he observed any wires associated with or around the conduit when he saw the condition earlier in the day, and his response was, "I don't remember." He again says it at page 724 of the record, and later on page 759 of the record, he reiterates that he doesn't remember if the wires coming out of the pipe were there when he did his walkthrough earlier that morning. Additionally, we can't pretend that Mr. Hubert, his sworn statement is not part of this record. That was also not acknowledged by the lower court. In that statement, Mr. Hubert says that the wires were curled up and laying around, and that the premier electricians should have put protection over it, and he doesn't know how long it was unprotected. This evidence tells a different story than respondents' contentions here that the wires weren't present when they were observed that morning. And whether Richard Hubert saw those loose wires during his walkthrough before the happening of the accident is an issue that's in question here and can only be resolved by the trier of facts. With respect to constructive notice, we have to turn to the testimony of the witness, Nicholas Cocovizo, who the lower court also did not acknowledge his testimony in the record. It's undisputed that Mr. Cocovizo was in that conference room where the plaintiff was injured from the opening of the job at 7 a.m. that morning until the happening of the accident at 7:30 that morning. At page 331 of the record, Mr. Cocovizo testifies that he did not remember seeing any electricians working in that room prior to the happening of the accident. He also testifies that the only other person that could have witnessed the accident was the shop steward. He's continuously asked about who was in the room at the time, and he never mentions any electricians. And plaintiff contends that if anyone were to see electricians working in that room that morning, it would have been Mr. Cocovizo. Both the plaintiff and the witness, Martin McGuire, described this room as a small room. Not only would Mr. Cocovizo have seen the electricians that were working there, but he would have had to seen the data company who allegedly ran wires that morning as well. So two separate companies come in, run wires, and Mr. Cocovizo doesn't see any of them.
Ms. Gomez, your time is up, so wrap up your argument, please.
Sure. Since my time is up, I'll jump quickly. I'll rely on my brief regarding my Labor Law 241-6 arguments, but I would like to quickly point out with respect to the 241-6 argument that the integral with the work defense is a very fact-driven defense. And unlike the case law cited to by the respondent, these wires were not in their final resting place. They were not in the place where they needed to be. They were left strewn on the floor, and they caused the plaintiff to fall. The case law that respondent refers to involve things that had to be specifically where they were at the time and caused injury. This is not the case here.
Okay, thank you. All right, let's hear from ACC, please.
May it please the court, my name is Nicholas Herzler and I represent the ACC defendants. Just pointing to first of all, the notice issue, counsel pointed to page 673 of the record for testimony from Mr. Hubert that he did not remember seeing any wires, but he testified in a lot of detail at 704 of the record, and he explained that when he went at 7 o'clock, he says at 7:30 in the morning, this is a direct quote from his testimony, at 7 o'clock in the morning, they were not pulled. And he explains how it only, first of all, there's other testimony that it only took 30 minutes to get the wires through. So he goes there in the morning, he explains that there were no wires in the trench. It's the wires and not the trench that caused the accident. And he didn't have notice when he went and did that walkthrough in the morning. And then later on, they come through and it turns out the wires have been pulled in that 30-minute interval. That's not an actual notice or a constructive notice. And as far as the electricians working in the room, there's a lot of testimony that they were still there. McGuire testified at 1023 of the record. He said, in detail, were they still working with the tubing and wires? I would say yes. That's at manuscript 26. There's testimony from Hubert at 690 and 91, 776. He says at 752, the electrician was still piping it out. There's a lot of testimony.
I mean, Counselor, based on what the plaintiff's attorney said and based upon what you've said at these different pages in the record with several different people testifying, isn't there in fact a dispute which can't really be resolved on these papers as to whether or not the electricians had finished in the room when the accident occurred? I mean, the workday had not been very long. The accident was claimed to have occurred around 7:30, and there seems to be a lot of different people testifying as to some disputed issues as to what was going on prior to that.
That's a great question, and what I would say to that is the only testimony that she's pointing to is people saying, I don't remember. So like if you look at 673, Hubert says, I don't remember. But if somebody doesn't remember and somebody else says that they were working, then you don't have a question of fact. You have unrebutted testimony from witnesses on the one hand saying that they were there, and then you don't have somebody saying that affirmatively saying there was nobody in the room or that he definitely saw wires at 7 o'clock in the morning. That's not a real question of fact. It's just people saying that they don't remember. What is the jury going to resolve with that testimony?
Well, let me ask you something else. Wasn't there also a dispute as to whether ACC or Premier was responsible for covering the trench where the wires were? I'm sorry, I hear some echoing, but I don't know where that's coming from.
I'm sorry, I hope that echoing is not coming from my end. I hope that's not a technical difficulty, but I mean, as far as the testimony from ACC was that they were responsible for cleaning up garbage, but even if they were responsible for covering the trench, again, they're still working on it. They pull the wires through. The testimony was we pull the power wires through, and then the data company has to come in and pull the data wires through. You can't cover up that trench until all that electrical work is done, and so you can't. It's not ready to be covered up at that point, and. You know, the plaintiff, by the way, we skipped the supervision and control element. The plaintiff skipped over probably for good reason because, you know, plaintiff testified, I had no supervisor at 4:01. So, you know, if the room was not supposed to be entered at that point, that was up to the plaintiff not to do that. You know,
I thought there was also testimony that somebody had directed, that somebody from ACC had directed Mr. Hammer to go into the room to stop somebody else from what he was doing, and that's when he fell.
Your Honor, I don't know. I don't know what the reference where that citation would be, and I don't recall that testimony. I know that, you know, the plaintiff's argument essentially was that, you know, Huber had some control over who was supposed to go in the room. But if you look at the actual record, it really shows that he had to defer to the electricians as to whether it was ready or not. And Huber did not have control over who goes in there. And they can't, for example, at 726 and at 719 of the record is where he says that. I would also point out, by the way, before my time is up, I wanted to mention that
your time is already up. It's already up.
I'm sorry about that. If I just finish this really quickly, even if the plaintiff prevails on this, it's not a moot point that we're still entitled to indemnification and attorney's fees from Godsell and Premier, and that issue is not moot. That was an error by the lower court in dismissing that branch of our relief. And with that, I will rest until my rebuttal.
All right, let's hear from Premier Electric.
Good afternoon. May it please the court, Sim Shapiro from Baxter, Smith and Shapiro on behalf of defendant respondent Premier. We have a case here where ACC's claims against my client for indemnity are barred by the doctrine of anti-subrogation. They've already been found by the lower court to be an additional insured under my client's policy. And in arguing against that, ACC has argued, and I'll quote, because the ACC defendants are not insurers it is difficult to understand how the anti-subrogation rule could somehow bar the indemnity claims here. Premier errs in confusing the separate issues of coverage and indemnity. They also say anti-subrogation is entirely beside the point. Actually, it's just the opposite. The whole premise of anti-subrogation.
The whole point, yeah.
Correct. And Your Honor, Justice Gish, you may recall, I was actually before you about a month ago, and I believe Justice Moulton was also on that panel. And at that time, one of my colleagues again tried to use that tactic again, saying, oh, we still have the contractual indemnity claim or the common law indemnity claim. Anti-subrogation is totally separate. And Your Honor asked, how would that work? And my colleague that day didn't have an answer, and there's no answer, of course, in ACC's brief. And the reason is the whole premise of anti-subrogation is just that. If you're an additional insured on a policy, which not whether I agree with it or not, that's what's been found by the court. If they're an additional insured on the policy, they have no claim for common law or contractual indemnity. And as Your Honor said a month ago,
and who is, has there been a defense tendered? Because that's always important too.
Yes. I know we got in the mail a package of their bills. So yes, they've tendered it. Yes, that's what was found by the lower court. And as I've noted,
has it been accepted?
I don't think it's an issue of being accepted. The issue is that the court found it.
And the court directed what? Your insurer to provide a coverage to the owner defendants in this case. Isn't that correct?
That is correct.
That was in a separate DJ action?
That was. And in fact, they made the same kinds of arguments. And I pointed out the arguments, the relief that was sought in that other motion, which has been decided, is essentially what they're looking here. So to say, oh, ignore all that and just, are they asking for two sets of checks? That's obviously the premise of anti-subrogation is you don't get that. And, similarly, some other arguments that they made, which was, we still have a breach of procurement of insurance claim, which again, by its very nature, necessarily that claim would be dismissible if in fact there's been a finding that they are an additional insurer in the policy. Same thing with the common law indemnity claim to say, well, they haven't really argued against it when in fact the entire caption of my point of law references all the indemnity claims, but above and beyond that, not only barred by common law indemnity and not only barred by anti-subrogation, but as has been pointed out here, since there's been, to the extent there have been findings of issues of fact with regard to the negligence of ACC, of course, necessarily they wouldn't be entitled to indemnity, common law indemnity for my client anyway. So, these are respectfully, these are improper arguments being made by ACC because there have been findings already. And as Your Honor said that day, it's the same thing here today. We're really done here because anti-subrogation bars those claims.
All right. Thank you. All right. Let's hear from Godsell Construction.
Good afternoon. May it please the court. My name is Laura Matera. My firm represents Godsell Construction. ACC admitted in their motion papers to the lower court that they're being afforded a defense under Godsell's commercial general liability policy. So they have not sustained any damages. They got defense and indemnification under the primary policy.
So, and we have anti-subrogation here too?
Yes.
Yeah.
Their claim had to do with coverage under the excess policy, and in claiming breach of contract to procure insurance, they only attached in their moving papers an email from Premier's carrier, Merchant Mutual, declining the tender. So they didn't make that claim. Very quickly with regard to indemnification, we're not even at that point. There are a lot of questions of fact that the court appears to be finding, but if the lower court's decision with regard to plaintiff's case is reversed. But the indemnification provision here at issue does not require Godsell to indemnify ACC simply because an incident arose out of its work. It requires something more, that it be caused by an act or omission. So it is not as broad as ACC has argued, and the cases that they cited are not apposite because this is a narrower clause and there is nothing in the record that would show that the claim arose from an act or omission of Godcell, which had nothing to do with placement of the wires, which had nothing to do with protection of the wires. Thank you. I have nothing more.
Okay. All right, let's hear from the plaintiff on rebuttal, please.
Thank you, Your Honor. I don't want to take up much more of the court's time, but I do want to note that Judge Kapnick, you hit this right on the head. The record here shows conflict in the testimony regarding the issue of notice. There is contradicting testimony. That's why I didn't move for summary judgment. Incidentally, that's why Premier didn't move for summary judgment. No defendant moved for summary judgment except for ACC. This case cannot be resolved on summary judgment because of the conflicting testimony in the record. And as to Judge Kapnick's, your question regarding who was responsible to cover, yes, there is testimony in the record. Martin McGuire actually testifies that it was ACC's responsibility to cover these types of trenches. The Adam Scheffler for Premier Electric says that it was ACC that was supposed to cover these types of openings and protect the area. Mr. Hubert says that it could have been the laborers, which were workers of ACC, or it could have been the electrician. Also, all a question of fact. Thank you.
Okay, thank you. And we're going to hear from ACC.
Your Honor, during plaintiff's argument just now, I didn't hear any specific citation to anything. As I pointed out earlier, there's no genuine dispute in this record because we have a lot of testimony that there was no supervision and control by my client, at most general supervision and control. There was no notice whatsoever. It was a 30-minute window that these wires were pulled through. And also that there was a lot of testimony that the electricians were definitely still working on this project. They hadn't pulled the data wires through. So I don't see how counsel can plausibly claim that, there's no electricians still doing work in this particular room. The testimony flatly contradicts that when viewed as a whole, even though a few people said they did not remember. As regarding Godcell's counsel just argued briefly that there's a negligence trigger in the indemnity language. That's not true. The contract language is clearly set forth in our brief, and it says at page 1066 of the record, obligations under this article shall apply regardless of whether or not any such claim, liability, loss, or expense is or may be attributable to the fault or negligence of the subcontractor. That language applies to both Premier and Godcell. The coverage and indemnity issues are just not resolved on this record. There's still open.
What about the anti-subrogation? If you're getting a defense, how do we have to go any further than that?
Assuming for the sake of argument that plaintiff were to prevail on the appeal, I don't see how the coverage limits are resolved on this record. How do we know what plaintiff's damages potentially could be versus what their coverage is? And as we pointed out in their brief, they didn't purchase the coverage that they were supposed to get. And none of that stuff has been resolved if plaintiff were to prevail. Again, it's our position that plaintiff should not prevail on the appeal. But I don't see how they can claim that we purchased all the right coverage, and if plaintiff were to obtain X number of dollars, that's definitely covered and we didn't do anything wrong. On this record, it hasn't been established.
Okay, thank you. Thank you. I miss it. Thank you all. Thank you.
Thank you. Have a good day.
You too. Okay, People versus Muhammad.
Good afternoon. Benjamin Luckenbecker on behalf of Rashad Muhammad. May it please the court. Mr. Muhammad's sentence of 10 years incarceration, 5 years post-release supervision is excessive and should be reduced to 5 years incarceration plus 2.5 years post-release supervision. Mr. Muhammad does not contest the seriousness of his convictions, and particularly his first-degree manslaughter conviction. But 10 years is a significant amount of time to spend behind bars. This is a very serious sentence for anyone, and even a reduction here would represent a severe punishment for Mr. Muhammad, especially, who had never been convicted of a single crime and was thus facing his first ever time in Rikers and then subsequently in prison. and faced significant mental health struggles, including serious depression, which manifested in low self-worth and suicidal ideations that persisted during the pendency of the case.
This is Judge Gish. Wasn't that known at the time that the plea was accepted by the trial court, his mental health issues?
They were known by the sentencing court, Your Honor, but first, that does not preclude this court from reducing an excessive sentence.
We
And
understand
secondly,
that, but I'm just trying to understand, are we dealing with something unknown by the trial court?
Right, Your Honor. So this material was in the record, but much of the mitigation put forward on appeal actually comes from other parts of the voluminous record, specifically the 730 evaluations. And at sentencing, although the court did acknowledge Mr. Muhammad's remorse, other than that, the court really just imposed the promised sentence without considering this mitigating information. Now, the prosecution faults Mr. Muhammad for seeking a sentence reduction here rather than mental health treatment inside prison. But the fact is that Mr. Muhammad has sought out such treatment wherever he has been placed, and no prison can give him the therapeutic treatment that he needs. A reduction here would allow Mr. Muhammad to get mental health treatment alongside his loved ones in his community, and he would still be supervised at this time. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
Any questions, colleagues? All right, let's hear from the people.
Good afternoon. May it please the court. Catherine Reed on behalf of Respondent, the Bronx District Attorney's Office. This case involves the senseless and tragic killing of 45-year-old husband and father, Jamal Taylor. On February 12, 2014, Mr. Taylor was innocently gathered in an apartment building stairwell celebrating a friend's birthday when defendant, unprovoked, stabbed Mr. Taylor in the neck, perforating his jugular vein and subclavian artery. Defendant proceeded to drag Mr. Taylor down several flights of stairs while continuing to stab him in the left flank and arm before leaving him to die. Then, while incarcerated,
Justice Moulton, I think the circumstances of the crime are acknowledged by the defendant. But what we're dealing with here is a defendant who has a family history of mental illness and has manifested very serious mental illness himself. And the question is, in the interest of justice, should we reduce the sentence? So could you speak to that? We're talking about the defendant's current mental illness.
Yes, Your Honor. So the sentencing court already considered these factors when it imposed the agreed upon sentence. They were factored into the judge's decision as well as the people's decision to extend and offer this lenient. And as this court has long acknowledged, the trial court is in the most advantageous position to determine the proper sentence. And additionally, there was a CPL 390 evaluation done, and it was determined that the defendant did not meet the criteria for schizophrenia or bipolar disorder. So again, I would just emphasize that this was a generous plea deal in which the defendant was sentenced to 15 years less than the maximum for first-degree manslaughter and received a concurrent one-year sentence for his attempted promoting prison contraband conviction. And defendant here cites only factors that were before the sentencing court and no extraordinary circumstances warranting a reduction in his sentence. And thus, having received the benefit of his bargain, the defendant should be bound by its terms and the judgment should be affirmed. If your honors have no further questions, I rest on my brief.
Any questions, colleagues? Okay, let's hear some rebuttal.
Thank you. Again, we do not contest the seriousness.
Counsel, this is Judge Arnold. I have a question. You know, what concerns me or what really troubles me is when we have these, well, for me at least, when we have these arguments about excessive sentencing and you have the component of clear mental issues with respect to the defendant. What I would like to see is that, you know, as my colleagues have noted, this was all before the sentencing court when it was imposed, when the sentence was imposed for 10 years and 5 years PRS. But you're making the argument now, I would think, that it's currently that he is suffering, continuing to suffer mental illness because you're saying that he's not getting the treatments or he's not getting the treatments in while incarcerated, correct? So my concern is, what troubles me is that I don't have anything in the record that supports that. I mean, I would like to believe you, but I'd like to see something in the record. And I know you're caught in a sort of in an awkward situation because you have what you have in terms of the record, but then you're asking us to give you relief based on your say-so. And I can't, I was just taught from a long time ago, I got to see it, I can't just, you see where my difficulty comes in? I mean, I'm hearing your interest of justice and argument. I really am, but I have nothing more than what you're saying, that he's not getting the treatments in the facility.
Right. And so I do appreciate that you can see the conundrum because we are constrained to the record here. But actually, in this case, we do have evidence from Mr. Muhammad's 4 years at Rikers pretrial in which he was
That's all
suffering from-
pretrial, but that's still all pretrial. I'm talking about right now as he's incarcerated. And there are ways in the CPL actually to get us the records. You know that? There are ways. I've seen it already. And that's what I need to see. I mean, I'm always troubled by this, and it really bothers me greatly because I can't make a decision. I can't make an educated decision based on I don't have anything in front of me. You're asking us to question the sentencing court when the sentencing court had what it had in front of it, right?
I understand that, Your Honor, and I can represent to Your Honors that Mr. Muhammad is currently in the mental health unit at Franklin Correctional Facility. However, I brought up the Rikers information known from Rikers only to show that for an individual in Mr. Muhammad's position who had never, ever been even in jail before, being confined had severely deleterious effects that render a 10-year sentence especially severe. And that is true. That was true in Rikers and remains true in prison. And so if there are no further questions, I would simply ask Your Honors to reduce Mr. Muhammad's sentence. Thank you.
Thank you. Thank you both. Freeburg versus the City of New York. You can proceed. Ms. Casaneri, are you with us?
Good afternoon.
Good
May it
afternoon.
please the court. My name is Carolyn Cantaneri. I represent the plaintiff appellant William Freiberg. It's respectfully submitted that defendants, respondents failed to make prima facie showing in this case and were not entitled to summary judgment. They failed to show that they did not create the condition, which included the worn out steps and the lack of handrails, which were removed. And they failed to show lack of notice, including that they failed to show by any witness when the area was last cleaned and inspected.
Well, what is really the cleaning and inspecting have to do with it? This was in the middle of a rainstorm. So I mean, whatever that was on it or clean would have been washed away. I mean, I don't really get that argument. I also didn't think, by the way, that the expert was very clear as to the information as to the removal of any handrails.
Well,
Except by just stating it.
With respect to the defendant's burden, it is their burden to show that they did not create or have notice of the condition. Since they did not produce any witness to state that it was cleaned or inspected on the date of the incident, I feel that they did not meet their prima facie burden. The water puddled in that area due to the fact that the step was so worn down. It was a granite step that was worn to the point that it created a pitch, and that's stated in our expert affidavit, stating that the pitch was 1/4 inch instead of 1/8 inch. With regards to the defendant's burden, defendant Lasaga was responsible for the structure of the building. This hasn't been rebutted.
Can I stop you for a minute? Let's deal with the handrails. Let's assume for a minute that there were handrails there and they were removed. And there seems, at least in the pictures, to be some evidence of that. Right. So the defendant in the prima facie case says, you know what? Handrails, schmandrails, they're not required under law. And there's no response to that. There's nothing. So how do we reconcile that as a basis for liability?
Well, first, there is an issue of fact concerning the handrails because the city witness, Sarita Cotton, states that she saw the hole and the orange patches before July 2nd, 2014.
I said I'm going to concede for you that, and there is some evidence that there were handrails there before, but if they're not required, then how can they be involved in the cause of the accident at all?
In relation to this dislocation, our expert, Thomas Turkel, does state that the handrails were there and were required based on the building code.
No, he doesn't say that, actually.
Well,
I
Your
wish he
memory of
did.
loss.
I wish he did. He doesn't.
Yeah.
Well, he does say that they were removed and
Just
replaced.
say
And
they
were
were
never.
removed, and I'm going to give you that issue again. I'm going to give it to you. I'm going to give it to you. Why does that create an issue of fact about whether they should have been there or not? If you remove something that doesn't have to be there, how can that be responsible for the accident? How can that cause the accident? They weren't required to put them there.
Because there was case law that was cited, Courtney versus Abro Hardware, 286 Appellate Division 261, which is a First Department case. And it does state the absence of a handrail and plaintiff reaching out to break his fall is the proximate cause of an accident. So based on the case law,
Was that a handrail that was otherwise legally required in that case? I think we're going around in circles because I honestly, I'm not really feeling that you're answering my question. Which is, what did they violate by not having? What building code provision did they violate by not having a handrail?
Well, New York
And
City,
does it matter?
New York City Administrative Code 28301.1 states all means of egress shall be maintained in good working order. So the fact that there is no handrail and there was nothing for the plaintiff to reach out to.
So you're not basing it on a specific requirement for a handrail for this outside step, but just generally for a safe egress. Okay, I got it. Okay, I'm going to ask you to finish it. Go ahead.
This is Judge Owing. I have a question. Didn't your client testify that he slipped in a puddle of water, but he gave no testimony that he reached out to try to grab a handrail? Because then in his affidavit, he said that he was reaching out for a handrail. It's an inconsistency there, right? Isn't there?
Well, with relation to his testimony, he was not asked at all during his deposition, did you try to reach out for anything? His testimony was that there was water pulled at the location due to the worn out step, and he felt like it was ice underneath him. And he also then clarified in his affidavit, since he wasn't asked that question, that he had nothing to grab onto, which was also another proximate cause of the accident.
Well, okay, all right.
With respect to the defendants, their expert, Michael Kravitz, does not show anything concerning the worn out step, the fact they don't discuss the handrails at all. They don't discuss
That's
that.
not true. He does discuss the handrails. I don't understand. He says the handrails were not required by law, that you're mistaken. The provisions you rely on don't apply. What else can he do? And he does discuss the condition of the worn out stairs. He has done calculations on the coefficient of friction.
He does this 4 years post accident, and doesn't verify that the steps are in the same condition. The accident happens in 2014. He doesn't go out until July of 2018, and there's no one verifying at that time that the steps were in the same condition. Whereas Mr. Turkel, which is the appellant expert, went out 9 days after, took measurements, reviewed the transcript, photos, wrote a diagram, stating that all of these things were deficient, including the worn out steps and no handrail, and the fact that it was puddling in that area.
Okay, I'm going to ask you to finish your argument because you're over your time.
Okay. With respect to the lower court decision, we feel that they did not make a prima facie case, that the decision should be reversed because both defendants did not show that they did not create the condition or have notice of it. So we ask that the decision be reversed in this case, Your Honor.
Okay, thank you. All right, let's hear from the Lasaga defendant.
Thank you, Your Honor. Richard Lane on behalf of Lasaga. Lasaga, as we stated in our papers, was an out of possession landlord in this case. The New York Police Department occupied the building, and pursuant to that lease, Lasaga was not responsible to maintain the premises on a daily basis. And in this situation, the hazard at issue involving falling rainwater, that's not really at issue. However, under the lease, Leslie only had the responsibility to come in and remedy any defects that were brought to its attention. In this case, there was absolutely no notice whatsoever to any party, including the plaintiff, who had worked in this building for I believe, 1.5 years. There was no notice regarding this alleged worn step, and we feel that the handrails were not required, but none of these issues were raised to Lasaga. And we do not believe that the plaintiff's expert established that this worn step is an inherently dangerous condition. There is a statement that it's simply worn without sufficient calculations on that at all. So, Your Honor, we feel that this is a storm in progress case, and that plaintiff is seeking to circumvent that by pointing to an alleged worn step or handrail, but the evidence just does not support that.
Okay, thank you. Let's hear from the co-defendant.
Good afternoon, Your Honors. Eric Lee for the city. As to the city, this court should affirm the order on appeal. Freiburg has no answer to the mountain of case law on sudden and ongoing precipitation. As courts have held time and again, a walking surface made wet by rain is simply just not a dangerous condition. And this is because
what about his testimony that in fact this wasn't just a step that was made wet by rain, but that it was so worn that the water kind of pooled in the area and gathered in the area, and it was that puddle that caused him to slip?
Sure, Your Honor, a couple of points on that. First of all, it's very clear based on plaintiff's complaint and based on how Supreme Court addressed this issue, we're not responsible for structural repairs. And this is clear on page 299 of the record. It says landlord shall make all external and structural repairs. So first of all, we're not, as all parties have recognized, we're here for the day-to-day maintenance, not the structural issues with the steps. But as we explained in our brief, even if you were to entertain plaintiff's case as a quote-unquote structural defect case, this court has said, first of all, a worn step is not an actionable condition. So 0 plus 0 still is 0. A worn step plus a storm in progress doesn't suddenly transform this into a dangerous condition. And we cited numerous cases that made this clear. Even if you were to say, fine, we accept that, the experts' evidence that plaintiff submitted here are conclusory and don't amount to anything. He says he measured the step and it had a 1/4 inch pitch. He acknowledges in his expert report that steps are naturally pitched to ensure that actually rain and debris flow away from the steps. But he doesn't cite, the expert didn't cite anything to say that the steps should be pitched a certain amount. He just simply asserted steps are usually 1/8 inch as opposed to 1/4. It's not based on anything. And if anything, this court and other courts in New York have said the best way to sort of get at how slippery a step is, structurally speaking, is the static coefficient. We cited case law showing that's the natural way to do it. Tellingly,
well, let me ask you about the coefficient of friction. You didn't put in an expert affidavit on that, did you?
We didn't put in an expert affidavit yet because we're not responsible for the structural conditions.
Well,
this was Lasaga.
Regardless, you're trying to avoid liability. Are you relying on
We're
Lasaga's
not liable
expert?
on the structural basis, so we didn't have to put in an expert. So it's not about us avoiding liability. It's us pointing out that the evidence as submitted, as Lasaga's experts put in, shows that this is the static coefficient of the step. And he's the only expert that put in any evidence on that.
Right, so you're relying on that.
Well, we're not relying on it because we're relying on it.
I understand. You don't think you should, even if it didn't meet the coefficient of friction, you don't believe you're responsible for it. But you are arguing to me, in any event, it did meet the coefficient of friction to be safe. Correct?
Right, that's correct.
So you're relying on it to that extent?
That's correct.
Okay.
That's correct.
All right, understood.
Okay.
Understood. All right, anything else, Mr. Lee?
No, I don't have anything else on the cross appeal to spare Lasaga for doing a rebuttal. I mean, we rest on our briefs. We think that point is quite clear. So unless the court has any questions about the cross appeal, I would simply say the court should affirm with respect to this.
Any questions, colleagues? Okay, let's hear from the plaintiff on rebuttal. Unmute yourself. You need to unmute yourself. Yeah.
Okay.
Got it.
So with respect to, thank you. With respect to the storm in progress, it has been shown that if there's something other than the storm in progress that caused the accident, which here it's the worn out steps and the lack of a handrail, then the burden shifts, and that's Bernston versus Randrick enters Corp 135 AD 3D 973, which is cited in the papers here. The city did not meet their burden because they don't have an expert to rebut anything concerning the steps in question, and their own witness, Sarita Cotton, didn't testify when the area was last cleaned and inspected. She also proves the fact that this is an exterior staircase. There's only one entrance in and out of the building. She also states that there were no handrails, and she did see that hole in the orange patch and cracks at the location. With respect to Lasaga, they are not an out of possession landlord. They're at the building once a month or once every 2 months. They stated that they were responsible for the 3 steps in front of the building per their own testimony, and their own memo of law admits that the lease provided that Lasaga was responsible for the structural aspects of the building, which would have included the worn out steps as well as the handrails in this case. We do not feel in this matter that the defendant respondents have met their prima facie burden, as there is many issues of fact concerning the conflicting testimony, as well as the differing opinions of expert Kravitz that didn't do his inspection till 4 years later versus the plaintiff appellant Thomas Turkel's expert affidavit and report, which was done 9 days after. The fact that there are differing opinions would warrant a denial of summary judgment, as well as the fact as there's issues of fact concerning the differing testimonies in this case. Therefore, it's respectfully requested that the lower court decision is reversed and the plaintiff's complaint reinstated. Thank you very much.
Thank you. All right, Lasaga, you have 1 minute rebuttal.
Okay, thank you. With respect to the duty to repair structural defects, and this is not a significant structural defect, but under the lease, Lasaga had the opportunity to remedy any structural defects, but there was no notice at all given of that in this case, and we would argue that there was no structural defect in any event. And with respect to the time lapse between the expert reports, I feel like this is a new issue being raised, but this does not seem to support that the condition would be any different or would be any better. So after 4 years, but in any event,
Okay.
We lost you.
I think you're frozen. No. Your time is concluded.
Okay.
Concluded anyway.
It's
Mr.
okay. I'm
Lane.
fine.
Are you okay?
I'm
All right.
okay. Thank you.
Thank you all. Sorry for the technical issues we seem to have.
Thank you.
219 West 81st against New York State DHCR.
Good afternoon. May it please the court, Jeffrey Turkel for the Appellate. This case involves a fundamental rule of administrative law that the Court of Appeals announced in 1985 in the matter of Charles A. Field case. And what the court said, and I'll be very brief in describing it, is that if the agency is going to change its policy or its interpretation, then it has to explain why, because if it fails
Counsel, did you make this argument below?
No, Your Honor, but I don't think we could, and I have two answers for that. Number one is, it was not in, when you say below, I'm sorry, do you mean in Supreme Court or do you mean at the agency?
At either place.
Okay. At the agency, we couldn't raise it because it wasn't until DHCR issued its PAR order that we knew. Okay. As to Supreme Court, it was not raised. It wasn't until the appellate division proceeding that I found the case where DHCR held to the exact opposite. And in answer to your question, Your Honor, it's well settled that on appeal, a purely legal issue can be raised for the first time, and this is a purely legal issue. In fact, in the Field case, the court said that where the agency fails to explain its change of policy requires reversal on the law as arbitrary and capricious.
Well, Mr. Turkel, was it really a complete change of policy, or was the factual situation somewhat different in these two cases?
I think it was a complete change of policy, and I think that the factual circumstances are virtually identical. In the Field case and in the matter of Lafayette storage case, both Court of Appeals, the court said that in order for the Field test to apply, there have to be sufficient factual similarities between the two cases. In the 21 West 58th Street case, the finding was that the center window on the 11th floor of the lower sash is difficult to open, and the left window on the 9th floor slides down when fully open. In the challenged order, or in our case, the finding was the public hallway windows on the 11th, 10th, 9th, 5th, 3rd, and 2nd floors do not lock/have improper sash alignment. The bottom sashes of public hallway windows on the 11th, 10th, and 5th do not stay up when open.
Well,
I think that,
I mean, perhaps the agency, I can't go behind all of their ruling if they didn't cite it all, but there were a lot of windows throughout this whole building that were not working, as opposed to one or two, two perhaps in that other case. And this affected pretty much all the people in the building because it went, the 11th, the 9th, the 7th. I mean, it was like in all the building, these windows that were having problems.
well, I would respect.
Yeah, there are 25, I think, defective windows here. That's kind of different than in a building with two. That's why I asked the question.
Well, it's a fair question, and it's different in quantity, but not in quality.
Significantly, yeah.
Okay, Your Honor, but the real issue here is this. In the 21st Street, in the 21 West 58th Street case, you had defective public hallway windows. And in 2000, DHCR enacted its code provision 2523.4E. And that code provision set forth 25 examples of de minimis building-wide services. And it specifically stated, this is in the regulation, it said this schedule is not intended to be exclusive and is not determinative in all cases and under all circumstances. Therefore, it does not include all conditions that may be considered de minimis. So the regulation itself says these are 25 illustrations of what we consider to be de minimis, and we're cautioning everybody that the list is not exhaustive. In the 21 West 58th Street case, the agency, considering defective public hallways, said these conditions do not indicate any safety or hazard conditions and are of a minor nature and therefore correlate, and correlate is the key word, correlate with the de minimis examples set forth in the code. So what the agency said in 21 West 58th Street is, we recognize, as we've stated in the code, that there doesn't have to be 100% match, and that what we're really focusing here is on the spirit of the regulation, that if a particular condition comes close to, correlates to.
Counsel, if there were 50 windows in the building, would that differentiate it from matter of 21 West 58th Street?
No, Your Honor, because the issue is how strictly or broadly is the agency going to interpret its own regulation? In the 58th Street case, it said close enough is good enough. If it's close enough to, in kind, not in quantity, in kind to one of our enumerated examples, then that's good enough. In our case, the agency said the exact opposite thing. And what's at issue here is not, I would respectfully submit, it's not the number of windows or whether the windows fail to slide up or continue to slide down. It's how does the agency determine when it's interpreting its own regulation whether a condition is de minimis. In one case, it says.
I mean, I get your argument, but I've got to say that I don't see why the agency doesn't have the right to look at the whole record, and they actually, they relied on their own inspector who went back there. You were supposed to fix these windows, and there were a whole bunch of them throughout the building that were not working. And they say, when these are in public hallways, which are used by the tenants, it really is not de minimis. I don't really see it as closely aligned to that West 58th case as you are honing in on. I mean, I get your point, but I may disagree with it, speaking from the person.
May I ask a different question, Mr. Turkel? And it has to do with the timing of when you raised this. All right, so you have a proceeding where there is a question about whether there's going to be a rent reduction at all. Isn't that the time that you have to raise the argument that what they're looking at is de minimis? Because what we're looking at here, they've already made the determination a long time ago that the rent was going to be reduced. So now the question is really, did you comply with the order? And can you raise a de minimis argument now saying, oh, well, the original order, we know we didn't comply with this order, but it really doesn't matter because the original order was wrong. Is that okay?
Yes, because there are two reasons. In the rent restoration case, as opposed to the rent reduction case, and Your Honor is correct, there are two different proceedings. We raised the de minimis issue. And in the challenged order, the order that's on review in this case, DHCR considered and rejected the de minimis issue on the merits. If DHCR was of the opinion that this was a dead issue, that it had already been determined in another parallel proceeding, earlier proceeding, then DHCR had an obligation to say, you know what, this is over, and this constitutes some kind of collateral attack, and we're not going to do this. DHCR didn't say that, and it's well settled that judicial review of an administrative order is limited to the grounds invoked by the agency. If the agency thought this was an improper collateral attack, it should have said so. And I would also note that in Field, the court said, that in Wayne Sherbin, which is the case about the limited to grounds, it says if those grounds are inadequate or improper, the court is powerless to affirm by substituting a more adequate and proper basis. And in Field, the court said that if the agency doesn't explain its change in policy, then the order is arbitrary as a matter of law, even if the record otherwise supports the order. So to respond to Justice Kapnick's question, yes, the inspector found what the inspector found. I don't deny that. But Field takes that into account and says, no. The issue in a Field type case is consistency. And if the agency is not consistent in how it interprets its regulation, and I would submit that in the two orders we're talking about, the 2005 one and this one, these are absolute polar opposites about how DHCR considers and interprets Rent Stabilization Code 2523.4E. One is extremely strict and literal, and the other one goes by the spirit and is much more broad. If the agency does that, it's arbitrary and capricious as a matter of law, even if the record otherwise supports the agency's determination. So yes, the inspector found what he found, but I would submit that the two cases are substantially similar. In fact, they both involve defective hallway windows. I don't get the feeling in DHCR's order in this case or in the 2005 case that the number of windows was at issue. What they were saying is, in the earlier case, these don't really affect the tenant's quality of life. They don't really have any real impact on the tenants. And because in our list of examples of de minimis conditions, we noted public area windows, although we didn't specifically cite public hallways, this is close enough to that to warrant a finding of de minimis condition. I mean, I think the ultimate field inquiry here, and this is where I'll stop unless the court has any other questions.
Counsel, I have one other question for you, which is that some of the windows in the building that's involved in this case did not lock. There was no statement about that in the 58th Street precedent.
That's correct.
The absence of locks seems also to distinguish this from that other precedent that you're relying on, that you say that they had to follow.
I would respectfully submit it distinguishes it in at least what I consider to be a minor way. These are windows in the hallways from the 2nd through the 11th floors. You have DHCR cases where public hallway windows in the 1st floor don't lock. That's important because somebody can get in.
Listen, kids play in hallways, kids play in staircases. You know, they play building ring alivio, or at least they used to when I was a kid.
Yes.
So, you know, that can be dangerous.
Yes, but a window that locks can be unlocked. Okay, and kids who are playing Ringo Livio can unlock a window very easily. DHCR did not find that this was a safety deficiency. They never used the word safety. And in fact, in their brief, they said it was about light and air, as if anybody goes out into the hallway of an apartment building in New York City to get air. The owner in 21 West 58th Street did not suffer a building-wide reduction in services on essentially the same facts because DHCR broadly interpreted its own regulation. 15 years later, this owner has suffered building-wide rent reductions. And the question that I ask, which is the same question that the field court asks, is why is the agency treating these two landlords different? Why did one succeed? Why did one fail? If DHCR wants to change its policy, it's perfectly okay to do so. It just has to explain why, which is why I respectfully submit that this court should remand it to DHCR. At that point, DHCR can do whatever it wants. It can adhere to adult policy. It can explain why it's changing. But on the field case, this order is arbitrary and capricious as a matter of law. Thank you.
Thank you. Thank you. All right, let's hear from the DHCR.
Good afternoon, Your Honor. My name is Anita Shah. I appear on behalf of respondent DHCR. The issue in a rent restoration proceeding is whether the underlying surface defects had been cured. Therefore, the commissioner rationally based its determination on the fact that hallway window defects remained uncorrected. And I quote, "Here, the agency inspection found that the public hallway windows on the aforementioned floors were not repaired. The commissioner finds that the administrator properly relied on the results of the agency inspection conducted on August 29, 2018. As the final order was rationally based on the record, was not arbitrary or capricious, it was correctly upheld by the court below."
Well, Ms. Shah, what do you have to say in response to Mr. Turkel's extensive argument about the inconsistency of the way you have dealt with these cases as compared with the West 58th Street case, since he spent a lot of time on that issue?
I would say that the appellant has not actually established that the prior decision was the policy. In fact, it appears that this final order is in accordance with policy. And what the appellant is arguing is that the application of the code example in the final order is inconsistent with policy. But he hasn't established that the prior interpretation of the code was actually policy. In fact, I would argue that—
Well, what else could it be? I was going to say, well, what else could it be? Well, what is the policy?
Well,
where can we find it?
What the appellant is saying is that the loose interpretation of the code example was the policy. And I was—
I understand his argument. What I'm trying to understand is you're saying, no, that wasn't our policy. Well, that this case is our policy. How do we know that? Do we have any written statement, or do we have a cache of cases that are similarly the same? What do we have that shows policy?
First, we have the statute itself, the example itself in the code, which really leaves very little to interpretation.
Well, no, I think it leaves a lot to interpretation. The example given is not this example, right? It's not. It's talking about basement spaces, windows, right? But it's a non-exclusive list, isn't it?
Well, it says
de minimis
examples except for these these common windows are de minimis, except when they are used by tenants. Common windows may be considered de minimis, except when they are used by tenants. I don't see a lot of
that's not okay. All right.
Right, and in fact, I cited a case, Queens County Supreme Court, in my brief, matter of M&E Rubin LLC, DHR, upholding our decision to reduce rent based on lobby windows. And I quote the Queens County Supreme Court, windows that are sealed are de minimis only when they are in an area that is not used by the tenants. This is 9 NYCRR 25234325. The exact code example that appellant is saying is our policy to use about.
Your time just ran out, but we gave Mr. Turkel a lot of time, so I'm going to let you finish your argument. Go ahead.
So this Supreme Court case came before 25 West 58th Street Court, establishing that the court has also upheld that a strict interpretation of the code example. If the court has nothing further, I rest. Thank you.
Anything further, colleagues? All right, we'll hear from the Tenants Association.
I hope I'm on. Good afternoon, Your Honors.
You are on.
Thank you very much. In the discussion that we've been having, highlighted by Justice Kapnick, about the difference in quantity of the windows involved in the 2005 case and the quantity of the windows involved in this case, let's focus on what the underlying complaint that the tenants filed, a building-wide decrease in services. Could be perfectly rational that if two isolated windows in a building is not considered to be building wide, whereas the multiple windows in this building on 6 floors, on half the floors in the building, are defective, certainly that is a building wide decrease in services order. So there is value in comparing the number of windows and the number of floors in the 2005 case and the 2014 case. I adopt the legal arguments made by the DHCR in its brief. I don't believe that the field argument is properly before this court. I think that in order for the field doctrine to be entertained by an appellate court for the absolute first time, the underlying facts have to be essentially similar. They are not essentially similar at all. No way, no how. I'll just end by quoting, just to give your honors an idea of the attitude that the landlord has in this case. This is a quote from their brief to the Supreme Court in the Article 78. Quote, common area windows in public areas do not serve any significant purpose except to provide light and ventilation. Okay, that's what they're supposed to provide. And if they don't provide that, it's a building-wide decrease in services. If there are any questions, I'll take them. If not, thank you very much, Your Honors.
Any questions? All right, Mr. Turkel, your final 2 minutes.
Very quickly. The field case is important because it requires agencies, just as courts are required, to obey stare decisis, but not to be locked into stare decisis and to be able to change their policy over time. Agencies have a right to do that just as courts do, but they have to explain why. And when when counsel for DHCR was asked about the difference between the two cases, she said she wasn't sure that the earlier case was the policy. The policy is what the agency says, and it's how the agency decides cases, and it decides the rights of the parties and the rent roll in the building. That was DHCR's policy. DHCR's policy today is 180 degrees different from that. With respect to the number of windows, I'm reading from the 21 West 58th Street order that the inspection found that the center window on the 11th floor was difficult to open, left the window on the 9th floor, the sash slides down when fully open. These conditions do not indicate any safety or hazard conditions and are concerns and are of such a minor nature and therefore correlate with the de minimis example. They never focused on the number of windows. They didn't say there are so few windows that it's de minimis. They just said there's no safety problem, there's no hazard to anybody, so we consider this to be de minimis. So I respectfully submit that attempting to distinguish the cases based on the number of windows, it's not something DHCR did in the earlier case. There's no indication that DHCR looked at that. Mr. Gribben, I'm sorry, Ms. Shah, I'm sorry, I don't know how to pronounce it, talked about a Queens County case, which is not binding on this court. Those were lobby windows that do not close or that cannot be locked. That's an emergency egress issue, and that's a safety issue because if somebody can unlock a lobby window, they can walk right into the building. That wasn't the case here. DHCR changed its policy, and it never explained why. And the Court of Appeals in Field said that's important. That's not something that we should be looking past. If the agency fails to do it, it's the court's job to instruct the agency to take the case back and merely explain itself. All DHCR has to do is explain itself. It doesn't have to do anything more than that. And so I ask that the case be remanded to DHCR for them to adhere to their policy or explain why they're not. Thank you.
Right. Thank you. Thank you all. Right, the next case is People versus Watts.
Allison Kale on behalf of Mr. O'Neill Watts. Reducing Mr. Watts' maximum term of post-release supervision sentence, where he substantially served the majority of it, having just about 5 months exactly left of that sentence to serve, is very much warranted in this case, which has very unique circumstances. He's already served his imprisonment sentence completely. He took responsibility for these drug-related offenses, and not only that, he took responsibility for an offense that he didn't commit. He does not deserve to be on post-release supervision for an additional 5 months, where he's gonna continue to be unnecessarily exposed to COVID through reporting requirements and home visit requirements. He was 18 years old at the time that some of these overt actions were taken. He was a young adult throughout the entirety of this conspiracy. He's now nearly 30. He is not the same person that he was when he committed these offenses. The district attorney herself has recognized the problems with the post-release supervision system in this state. The most basic ones being that it's unequally meted out.
Although, let me just address that. It was a very interesting article, and thank you for bringing that to our attention. But the DAs in the article, essentially what they were arguing in favor of is a statutory change to our system of parole, as opposed to the courts just saying, gee, parole isn't working, and therefore we're going to address it case by case. Isn't that right?
Yes, Your Honor, that's what they are supporting reforms, but the reasons why the system is bad apply just as equally to Mr. Watts. And he has, as I mentioned, just 5 months left. The reasons that they've recognized are that it's unequally meted out along racial lines. It serves little rehabilitative purpose. And frankly, I don't know what rehabilitative purpose keeping Mr. Watts on post-release supervision for 5 more months is going to serve. He's going to face unequal threats of reincarceration for minor violations, which he's already faced for the past 2.5 years. When he took this plea, he was also pleading to a violent felony offense that had a post-release supervision sentence of 5 years. This 3 years was subsumed by that. We now know that he did not commit that offense. He was found innocent, and that was vacated and dismissed. So that affected the plea here. It affected the post-release supervision sentence that he got of 3 years, which again is the maximum. And this court has reduced in similar circumstances recently in the People v. Graham case, and a reduction is warranted here. And just quickly, the waiver here was not valid. The court mischaracterized the appellate rights, telling Mr. Watts, quoting, "There are no meaningful appellate issues because you have not gone to trial and there have been no hearings in this case." So the court should reach the excessive sentence issue because that waiver was invalid. And if there are no questions, I'll rest on the brief.
Any questions? Okay, let's hear from your adversary.
Thank you. May it please the court, Daniel Young on behalf of the Office of the Bronx District Attorney. Here, the defendant did validly waive his right to appeal the his claim of an excessive sentence. Regardless, the sentence imposed was fair and proper. As an initial matter, the defendant properly waived his right to appeal. When the court told him about his right to appeal, the court first explained his trial rights that are automatically waived upon pleading guilty. Then the court went to matters to determine the defendant's state of mind, asking him questions like, are you on any drugs? Do you understand the consequences of your plea? Things that go to state of mind. And it was only after that separation between the trial rights that the court turned to the waiver of appeal. When explaining the waiver of appeal, the court properly explained to the defendant that he was waiving his right to appeal as part of the plea bargain that he had reached with the prosecution.
Counsel, but the court didn't advise him orally anyway that there were certain issues that survived the waiver that can still be appealed. That may have been included in the written waiver, but wouldn't you rather move on to the substance of the whether or not we should reduce the sentence?
Yes,
you don't have that much time.
Thank you, Your Honor. As to the sentence, the 3 years post-release supervision is entirely fair and proper. Defendant took part in a 3-year-long conspiracy to sell drugs throughout the Bronx. Even in the overt actions of that conspiracy, there were, violent elements wherein he possessed a firearm. One of his co-conspirators fired a firearm, and one of his other co-conspirators shot someone in the back. There were multiple drug sales. This was not a one-time event. This was a long-term criminal enterprise in which they used violence to further their business. On top of that, defendant.
Do you know, this is Judge Gish, do you know when his parole, his post-release supervision is due to end? Do we have any idea?
I believe my adversary is correct. He has about 6 months left.
About 6 months. Okay, and can you explain to me your position on your adversary's position that the original plea, the PRS was in part, the reason that he agreed to it is because he had another conviction which had longer PRS, and that he would have had to be on PRS anyway, but that conviction has now been overruled, set aside. What impact does that have, or should that have, on what we do here?
That shouldn't have any impact on what's happening here. If defendant felt that now the terms of the agreement were no longer, if knowing that he wasn't also pleading to that violent felony offense, that the agreement wasn't going to be beneficial to him, then he had other avenues in which to try to have the plea vacated and go back to a pre-pleading posture. He did not pursue that, so there's no indication in the record that he wouldn't at any point have turned away this agreement by the people, even without having that plea to the violent felony offense.
Okay.
So,
all right. Your time is up. I'll let you wrap up, and then we'll hear from your adversary on rebuttal.
Thank you, Judge. All I was going to say is if your honors have no further questions, I yield the remainder of my time.
It's a good wrap up. Thank you. Any further questions, colleagues? All right. Ms. Kyle?
Just very briefly here, Mr. Watts took responsibility for these offenses. That's part of the reason why he's just seeking a reduction of his post-release supervision sentence. He's on supervision until August 16th. So those 5 months would make a really big difference for him. Again, I don't see the rehabilitative purpose to that. And to be frank, it's not worth the cost to the state to keep him on that supervision either. So we ask for any reduction of his post-release supervision sentence that would let him off immediately. Thank you.
Thank you. Okay, the next case is Shaw versus 20 East 64th Street.
I'm on. May it please the court. My name is Kenneth Roberts for plaintiffs, appellants, respondents, Mr. and Mrs. Shaw. Good afternoon, Your Honors.
Good afternoon.
Plaintiffs appeal from the trial court's order precluding them from proving their claim for loss of value of their home. With the time constraint in mind, I'd like to focus, Your Honors, on the most important point, and that is that we're not seeking on this appeal a specific award of damages. Quite the contrary. All we're asking for is a chance to present our case. What the trial court did was summarily dismiss our claim on the eve of trial before any evidence was heard, and 2 years after the summary judgment deadline. In a similar situation, 3 of Your Honors, Justice Gish, Justice Oing, and Justice Moulton, were on a panel that unanimously reversed an in limine order because it summarily dismissed a claim like this one. This was the Casalini case cited in our brief. There, as here, the defendants had timely moved for summary judgment, dismissing some, but not all, of the plaintiff's claims. As here, years later, on the eve of a bench trial, the defendants filed a purported in limine motion seeking dismissal of other claims.
Well, counsel, is it different because this isn't really, I don't believe, I get your point. Obviously, I was the one person that wasn't on that bench, but I'm sure, I'm aware of it. But it wasn't specifically a separate cause of action, but it was a theory of recovery. And did not that theory have to be very specifically included in the, contract between these parties? And that's what I'm concerned about.
Yes, it was. Yes, Your Honor is correct that it was not a cause of action. It was part of the breach of contract cause of action. And it was a claim within the breach of contract cause of action, which we specified in our first bill of particulars 3 years before trial. And 20 East and the other defendants moved for summary judgment, dismissing some of our claims 2 years before trial, but not this one. And it's important in the Casalini case, and also just last month, Justice Oing was on a panel that unanimously ruled in Kim versus KYW. Quote, plaintiff cannot use the motion in limine as a vehicle for partial summary judgment. That's a 2021 slip-op 00998 at page 1. Now, the defendants argue, as Your Honor was saying, that, well, we were just seeking an evidentiary ruling that the expert testimony was inadmissible. We weren't seeking to dismiss a claim as such, and the judge didn't dismiss a claim as such. But if you look at the record and look at what they argued and what the judge did below, you'll see quite a different story. In the record at Appendix 1582, the defendants themselves expressly framed the motion as a motion for summary dismissal. Quote, plaintiffs should be barred from pursuing a claim that there is a diminution of property value. Not evidence, a claim. Then they stated the relief they were seeking below. Quote, an order should be granted which precludes plaintiffs from pursuing any claim for lost profits in the form of diminution of property value. That's at Appendix 1583. These statements were incorporated by reference by 20 East, which is obviously the important respondent here, at Appendix 1786. And then further, 20 East in its respondent's brief on this appeal correctly characterized the order below as follows. Quote, the trial court dismissed plaintiff's claim for loss of market value. That's at pages 17 to 18 of 20 East respondent's brief.
Counsel, this is Judge Oing. Let's assume that you're correct, that the Supreme Court, that the trial court erred in granting the in limine motion. Let's put that aside for a moment. What is it in this agreement? And I want to get back to what Justice Caput said. Is it broad enough to cover, to me, an element of the damages for the breach of contract? I mean, that's what you're looking for. It's another element, right? You have the damage to the building. That's one element.
Exactly.
You have the alternative living arrangement. That's another element of the breach of contract. This is now what you're arguing, a third element, which is my loss of market value. Where is it then? How is it then, as Justice Caput said, shouldn't that be more specifically mentioned or stated in your indemnification, in the parties' indemnification agreement, or do you think it's broad enough to cover that?
I do think it's broad enough to cover that for two reasons. First of all, we're not just talking about the indemnification provision in paragraph 18.
Just using that term, right?
And then there were two distinct breaches of contract that the court found below. One, it was the one that you mentioned. Paragraph 3 says you got to excavate lawfully, and they didn't. And they caused the $6 million of damage. Boom, we have that.
Right.
Paragraph 19 says you got to repair your damage or pay for it. And that's a continuing breach today. Even though we have the $6 million judgment, they're appealing that. They're not paying, they're not repairing, and they're not paying, which is a continuing breach of paragraph 19. Even now, you would think 20 East is seeking to reduce the $6 million to $5 million on its cross appeal. Where's the $5 million? Let us repair the house so that we can put it back on the market.
But I mean, all that being said, I'm not sure you directly address both Judge Oing's question and my question that where, under what theory, under what case law, under what are you entitled to a loss of market value form of damages? That's what we're looking for. And that's what Judge Cohen felt that that was not something that was provided for. This was a contractual damages trial that you had. I know there's been a few different trials and they're bifurcated or trifurcated, and it was hard to follow that. But on the contractual damages claim, where is that aspect of damages provided for in your contract? That's really
I hear that, and of course the word market loss is not in the contract, but it doesn't have to be. Lost profits is never in a contract. But if someone breaches a contract and it causes lost profits, that's consequential damages, which you're entitled to prove if you have the evidence of the loss. And what's interesting is in lost profits cases, this court has ruled that you don't need to have actual sales of widgets or whatever it is that you lost your profits on. You can bring in an expert that says, this is the history, this is what they would have made, this is my opinion of the damages they lost, of the loss.
Mr. Roberts, I have a question now. Oh, I'm sorry.
No, it's all right. Go ahead.
I have a question, Mr. Roberts. And this clause, this agreement clause here, we're talking about the continuing the repairs, and that's where your market value loss element or damages are flowing from. That they didn't do any repairs and everything. What was the discovery, the deposition? Did the parties get deposed on these clauses? Because if there's an ambiguity, I mean, let's just say there's an ambiguity. What do the parties view this at? Did it include? I mean, at the time, and my understanding is at the time the agreements were entered into, the building was on the market to be sold.
That's right.
So when you're entering into the agreement, what were the main parties thinking when they put this together? I know you don't have market value in there specifically, but were the parties thinking about that or contemplating that when they put that all?
That's an excellent question. The discovery, none of the depositions delved into what you're talking about, but that's exactly the type of factual issue that we're entitled to present at trial. The house was on the market. It was being marketed for $42 million. Our appraiser said it was worth 35 at the time. if they knew, they might deny it, but we can prove that they knew it was on the market. And when you talk about the natural consequences of a breach of contract, is it foreseeable? Well, Judge Cohen felt absolutely not. It's not foreseeable. But what he didn't, I wasn't there at the time, I'm sorry. But what he didn't understand is that you don't have to foresee the precise loss or the precise damage. You have to foresee if this could have reasonably happened. And if they did $6 million of damage to the house, I think it's pretty foreseeable that it wouldn't be saleable. And if they refused their obligation to repair it, I think it's pretty foreseeable that the market could go up and it could go down.
So it's your, I mean, I'm looking at paragraph 18 of the agreement granting license, access, and indemnity, which is the agreement that your clients have with the defendants. And it, paragraph 18 is saying that they should indemnify and hold you harmless for any and all causes of action, damages, blah, 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 which may at any time be asserted against or incurred by Shah or the other occupants. And you're saying that this type of damages, obviously you would put forward an expert that would do it, prove that, and they would try to cross-examine or bring forth their own expert. I realize you need somebody to testify, but you're saying that could fit within the form of that, that could fit within the four walls of that paragraph.
Absolutely. I said there were two ways. Paragraph 19, natural flow of consequences, is one. Paragraph 18, importantly, subsection 3 specifically identifies breach of contract. And if you back up in that paragraph, one of your blah blahs was losses.
Sorry.
Any and all losses. So, I mean, does it, and so, I mean, do you really have to say every kind of loss that might be suffered? And let's not forget, when we're looking
at- It's a market loss, right. So that's a loss, right?
Of course it's a loss. And let's not forget
and
that.
I'm going to just, before we forget anything, Mr. Roberts, you are so way over your time, so wrap it up.
Okay, I'm sorry. I can address on rebuttal, but the fact is, the only consideration the plaintiffs received in this transaction was a promise to repair and a promise to indemnify against any and all losses. This was not a commercial transaction where they benefited at all. They were just being good neighbors. And all they wanted was to be, look, build your underground bowling alley. Just make sure, if you harm us, repair it. Make us whole. And that is all we're asking. Thank you, Your Honors.
Thank you. All right, let's hear from 2064, Ms. Turetsky.
Thank you, Your Honors. Good afternoon, and may it please the court. On behalf of defendant respondent appellant 20 East, there are 4 separate issues before the court today. And so in the interest of the time that we have, I'm going to endeavor to split my allotted time to focus on the 2 that concern 20 East obligations under the indemnification provision we've been discussing, entered into between 20 East and the plaintiffs. So to begin with, I'll address plaintiff's appeal. And 20 East sets forth that the trial court properly precluded the Vargas testimony in deciding the in limine motion practice here, and properly held that the testimony would be irrelevant to the damages alleged by the plaintiffs. Plaintiffs are making 3 arguments in advance of this appeal here. First, that the trial court erred in its reading of the contract language. Second, that the trial court improperly failed to find the indemnification sought for the market change is clearly implied in the contract. And third, that plaintiffs must recover this articulated market change loss to be made whole. So first, New York law is clear that in a property damage action, generally, in order to be made whole, the law permits a party to recover the lesser between the cost to repair to the pre-damage condition and a diminution in value, but never both. And it's important to note that the diminution in value measurement is always taken from the value of the property immediately before damage and immediately afterwards.
Counsel, this is Judge Owen. That may be the law, but if there's an agreement that says to the contrary, if the parties agree to it, then that law goes aside, right? That gets put on the side. So that's the question we had that we presented to the appellant. Justice Kapik and I were having the dialogue with him, saying that does that paragraph 18 and 19 is it broad enough to cover market loss?
Right.
I mean, we can state all the law we want, but the parties are free to negotiate and contract otherwise. And that's my
Absolutely.
question. And then
Thank
I
you,
asked the question about whether or not where did the discovery go about this? And surprisingly, he said they didn't focus on this. There was no discovery on these two provisions, on 18 and 19, as to whether or not it does include market loss, right? So now we got like another little conundrum here.
So that's true. There is nothing in the record where any party stated that there was an intention that 20 East would be a guarantor for changes in the New York City real estate market over any period of time.
So that the motion to eliminate them may not have been the proper motion to make then at that point. It's really a summary judgment motion, because if that's like, you got to make a point to say that those two clauses, 18 and 19, do not cover market losses, because that was in their bill of particulars. You knew that that's what they were looking for. And yet you waited to the very end, or somebody waited to the very end and said, look, this is an evidentiary issue. We don't want this. So that was sort of like that's kind of like a quick and dirty way to get rid of something when you realized that there was an element there, and just waited for the end, right? Because if you had made a motion for summary judgment, I would suspect that the Supreme Court would have said, oh, I think it's ambiguity. I think we got an ambiguity here because I don't have enough discovery on this issue.
I don't think there's any ambiguity here, Your Honor, because the contract itself makes no reference whatsoever to any obligation to indemnify plaintiffs for anything having to do with the market value of the property generally.
But it says losses. I mean, that's what Mr. Roberts brought up. And I mean, does it have to say market losses, or does losses cover market losses?
Well, it
think it's
says
arguable.
losses that are asserted against or incurred by the plaintiffs. And the trial court took very strong note of the incurred by requirement.
But that's the problem. That's the problem I have, counsel, is that it wasn't made on a motion for summary judgment. You're making it on a motion to eliminate. And of course, the trial court then is boxed in terms of what it can consider. Whereas where I think the way it looks to me is that it's more appropriate a motion for summary judgment, saying that there's no factual issue here, that these two clauses, 18 and 19, do not cover this element of a damage, this particular element, saying that it covers market loss. That's a whole different evidentiary standard versus a motion to eliminate, which is very restrictive in terms of whether or not, it's just two different animals in that regard.
Well, to that point, Your Honor, to the extent that Judge Cohen considered the argument that this would be brought under the indemnification provision and that plaintiffs had articulated an incurred loss, the judge said, secondly, that there was no, the articulated $11 million loss by the plaintiffs would not satisfy the requirements of New York law, that damages must be capable of measurement without any undue speculation. So that it would be not permitted on that ground. And second, because the fact cannot be overcome here, that there's nothing in the contract that even suggests any agreement that 20 East would be on the hook for changes in the market conditions over any period of time.
That's silence right there.
Okay.
Silence there.
I would actually like to ask a question about the speculative nature of this, and the fact that the contract doesn't specify. Not only doesn't it provide for the loss in market, but there's no indication on how that would be accounted for, what period of time we'd be counting. So in other words, right now the house is never sold, right? It's not sold, or it wasn't as of trial. That's
not
right.
sold, and it never
Right,
was.
not sold, and in fact, it's not even repaired. Is that true?
That's true.
All right. So it's hard for me to sort of wrap my mind around, without a formula in the contract, where we would count. What would be the time within which you could even count the market, or you would look at the market to figure out if there was a loss or maybe even a gain, and I think that's a question that actually supports your position about this being very speculative to just say market losses, to let the plaintiff come in here and say, yes, I want to measure it from 2018, but the market went up after that. No, let's measure it from 2020. Who knows, right? How would we measure it?
That's absolutely correct, Your Honor. That is something Judge Cohen noted in precluding Vargas's testimony in the bench trial that was concerned with only the breach of contract and contractual indemnification issue. And what Judge Cohen stated was that it would be an absolutely extraordinary, unusual burden for 20 East to make itself a guarantor for the market change, and that
But honestly, Ms. Turetsky, wouldn't the plaintiff had an expert that was precluded? That would have been the person that would have come in and put forward whatever they thought they could put forward if that claim had been allowed to proceed for the loss of market value. I'm not going to sit here now and figure out what the person would have said or what they would have based it on. And you also could have brought someone in and said, that's ridiculous. There's no way to tell. But that could be something that people could listen to. I mean, sometimes damages are not, absolutely, very, very clear. In lots of cases, that types of damages are not that clear. And you put different experts and the judge decides. So I don't think because it's, I'm not sure that would have been speculative as much as based on what some experts might be able to have testified to, what they could say, what they couldn't say, but it's possible. I'm not an expert in that area, but I would need an expert to hear from.
Well, regardless of what any expert would say about what the market value loss might have been over whatever specified period of time that they would be looking at, you can't get around the fact that the indemnification provision provides that there's only going to be a loss that is, quote, incurred by the Shaws. And what Judge Cohen discussed in rejecting the testimony of Vargas was, here, there's nothing that's incurred by the plaintiffs. It's simply a floating change in the market over this period of time that they're seeking reimbursement for.
Well, the
and
question,
without any
Turetsky, and opportunity costs, that they weren't able to sell their house. But I think the temporal aspect is important that Judge Gish turned on, that Judge Gish mentioned. And that temporal aspect is this: you have to pick a date of sale at some point to value the property as of that date of sale. I'm saying this because, and actually this does support your position. So one expert could say, I want to pick this date in 2018, which was a great date to sell this building. And the other expert for the defendants would say, no, let's look at the value of the building on another date where the value of the property was much lower. So since there is no temporal specification in the indemnity agreement as to how, whenever these market losses are to be valued, doesn't that mean that it is essentially speculative, as Justice Cohen said?
It's entirely speculative here. It's entirely speculative. There's no reference. There is actually, the agreement contains a reference to plaintiffs selling the property, and that provision in the agreement actually says that in the event that the property is sold, the rights in the agreement will inure to the benefit of the next owner of this piece of property. So to the extent the parties were thinking about a sale of the property, they put that piece into the agreement. There is nothing at all that says if anything happens to scuttle a sale, then it would be covered. And additionally, Justice Cohen also struggled with the fact that there is no evidence of any contracts, any scuttled contracts, any buyers. And you have to keep in mind that the property was actually actively listed on the market for 9 months, that plaintiffs would be expert marks as the market apex of $35 million. So the first point is $35 million that Vargas notes in February 2014. This license agreement was executed in September 2014, and then the damage occurred in November 2014. So the link to the damage at issue here is beyond nebulous, and it's absolutely speculative. And plaintiff mentioned lost profits. Certainly lost profits can be awarded as damages, but they can't just be completely speculative.
I'm thinking about this temporal aspect, so that, it strikes me then, it seems to me that the plaintiffs then did you a favor by not selling the property after the property got damaged. Because the way they could have looked at it, they could have taken a huge, I heard that it was being marketed at $46 million or something at the time. So that after the damage, if that would have dropped to like $20 million, they could have just sold it for $20 million and sued your clients for the $26 million difference then. So they did you a favor by holding on to the property and hoping that you guys would fix the property and repair everything. And it took you what? 2014, we're in 2018, and it still hasn't been fixed. Nothing has still
We're in
been repaired.
2021.
I mean, I'm sorry. Even worse. Even worse.
Worse.
Even worse. 7 years later, I think 7 years. 7 years later, they're still there. They're still living in the property. So they did you a favor. The way I'm listening to this argument, they did you a favor by not selling. The minute that place went cracked into two, and they could have sold the property for 20 million, took a huge loss, and then gone after you for the other 26 million. So they did you a favor in that sense. They saved you money.
I mean, whether the market moves up or down is always going to be
I'm
unknown.
just making the point. I'm making the observation that had they just sold the property at the point where that building got severely damaged as it is, and I saw the pictures, I saw the photographs. The photographs are worth 1,000 words. They could have taken a huge haircut and then sued all the defendants for the difference. So I'm just making that observation, because if we're looking at this temporal aspect here,
Well,
that's real.
let me just say that would have actually been allowed under the contract.
Right.
But you would have been dealing with a market value in 2014, because they would be entitled to the diminution in the market value at the time of the occurrence or the repair value. So yeah, but I think that's a different element of damages, maybe. I think. I don't know. I don't know. It's a very interesting case. All right.
I mean, the fact here is that we maintain it wasn't an incurred loss, because the fact is that it wasn't sold.
You know, I've been very lenient about giving you folks time. So let's hear from Urban. Go ahead. Urban Foundation.
May it please the court, Eric Leiter, Maura Lilling Naparty, for respondent, Urban Foundation Engineering. I'd like to begin by addressing some of Justice Owen's questions about the procedure here. The reason plaintiff's counsel couldn't tell you what the plaintiff said in discovery is because they refused to appear for deposition. There was a motion filed to vacate the note of issue. The motion was denied. They didn't plead their market value loss in their bill of particulars. So they were left in a situation where if they moved to amend their bill of particulars post note of issue, they would end up reopening discovery. The only notice they sent of any market value claim was through an expert witness disclosure. But that's backwards, because the expert has to be limited to...
So counsel, you're telling me nobody got deposed in this case?
The plaintiffs didn't get deposed, not until October of the 2018,
so
before
they did
trial.
get deposed. Oh, you left me with the impression that they didn't get deposed. They did get deposed.
They got this after, as part of the agreement that created the trifurcated trial.
Yeah.
In order to expedite how the trial would go, it was agreed that the plaintiffs would appear for a limited deposition, which they did. And it's only at that time also that they ever turned over any documents relating to the sale or proposed sale of their home, October 2018.
Okay.
So that's why the issue comes up when it does. And they're putting it as though there was a claim that was pled that then was taken out, as opposed to a claim they did not plead that they wanted to put in. And that's where the issue of the motion to amend their bill of particulars is so relevant. I'd also like to address the question about the temporal loss, because the plaintiffs here were quite clear that they were not looking to sell their home to withdraw the profit of however much the value of their home is increased. What they wanted to do was essentially a property swap. They wanted to sell their home in that particular neighborhood and buy another home in the exact same neighborhood that would have the same value. So there is no actual loss to them, because what they're doing, no matter what value you put on the home, if you said the house was worth $100 million, then if what they're going to do is sell the home and buy a different home in the same neighborhood for $100 million.
Wait, I have to stop you on that, because it sounds like, honestly, what they were doing was for tax planning, a 1031 exchange. You can't just swap. You can't swap for properties unless there is like value. So it is a sale. It's a bona fide sale, and it's recognized by the IRS. It just has different tax ramifications. So I don't think that's a really fruitful place for you to go down.
Well, to clarify, it's not that they were looking for a 1031 swap. They understood that as a practical matter, they weren't going to find somebody else who just wants to swap houses. But what they wanted to do, because they were intent on living in the same neighborhood, They just didn't want to live next to this particular neighbor, is they were going to sell their home for the sole purpose of buying another home at the same time in the same neighborhood. Those two houses are going to be identically affected by the market value.
That's a good enough reason to want to sell your house. You don't like your neighbors. And it sounds like this is not a relationship that's gone that smoothly. You got it. Okay?
Certainly, it's a fine reason. But
I
the issue
can't
is,
help but
how
think,
does the market value affect it?
Counsel, I'm listening to all these arguments. I can't help but think of one phrase: "No good deed goes unpunished." He let you into their house to get access so that you could build your whatever underground gymnasium, and this is what happened.
Well, to be clear, although he's represented it differently, the license agreement makes clear he received tens of thousands of dollars. He demanded
$100,000. To me, as I'm looking at this, if you didn't have access to his building, your client could not do what he wanted to do to his building, correct?
That's not correct.
Okay.
And I'll address that, because that was one of the issues with some of the other neighbors. Not all of the neighbors consented, and it just changes how the excavation is done. It doesn't change whether or not they can do excavation. So the project still could have gone forward. The house could have still had the same
It would have been more expensive.
You could have. You could have moved for licenses under the RPAPL, but still, it made it less cumbersome to just have an agreement. I mean, come on.
Of course, there was a benefit to them in doing it for both sides. But now, to also address the issue, since there wasn't testimony from the plaintiff.
It turns out not much of a benefit to them, really, after all this, but okay.
Well, so to turn now to the question of whether or not there was an abuse of discretion by Judge Cohen in limiting the scope of Vargas's testimony, what you, I think, have to come to first is Judge Cohen's
Well, they just
conclusion.
knocked him out. I mean, they didn't let him testify at all. It wasn't limiting the scope,
Oh,
was
he did
it?
testify. Your Honor, he did testify. He was the witness that the plaintiffs called to testify to what it would cost to rent a house.
The alternative living expense.
For the living expense, right.
Yeah. So the limitation, and again, we're talking here only about plaintiff taking issue with it in the context of the breach of contract claims, not on the jury claims. He's acknowledged that there's nothing to pursue, and there's no appeal that's going to be coming disputing that it was proper to preclude Vargas on the trial piece, or the jury trial. So when it comes to the bench trial, the very judge who's going to decide whether or not to make an award and of how much on this market value theory is already made clear that the plaintiff hasn't established the first parts he's going to need for the judge to ever get to that last piece where he would need Vargas's testimony. And when he looked at the clause, he correctly identifies this as being the standard license agreement clause. It is, in fact, literally verbatim the New York City Bar Association's sample license agreement. And trial counsel, although they have different counsel now, acknowledged on the record at page 4738 that the judge was exactly right, that this was written in, quote, the normal way, that there was no special language, there was nothing to indicate that there was some sort of special damages that the plaintiff and 20 East were negotiating in this agreement that would not be found in every other use of the same exact language in every other license agreement. And since it's not found there, there was no reason for the court to find it in this provision.
Counsel, I got to tell you, this is Judge Owen. What you just described to me sounds awfully like a summary judgment motion and not a motion in limine. I mean, I've been away from the trial court not that long to know that that doesn't sound like a motion in limine, what you just described to me. But okay, that's just my observation of what you just said.
Well, I would note that given that the discovery was received so close to trial, that could be reason enough to find good cause for the court to consider a summary judgment motion even at that late time. If we only got the records.
Yeah, that's not how it went down. Let's hear, we haven't heard from TriStar yet. Let's hear from TriStar Construction.
Good afternoon. May it please the court, Jonathan Schaub for the respondent, TriStar Construction. I'd like to take a step back here for a minute to point out that this entire appeal is procedurally improper and should not be heard right now. Plaintiff is effectively using an interlocutory judgment to bring up for review a motion.
Oh, counsel, let me stop you right there. So basically you're saying it's premature, right? So that at some point a judgment's going to come down and they're going to appeal it, right? So this issue, you're either going to decide it, either we consider it now, we're kicking the can down the road, right? It's not, it doesn't end this, right?
It doesn't end this issue, but there are reasons because the tort.
I know there's a collateral source argument left.
And there's also
collateral source argument.
Right, and there's also overlap between the issues in terms of what was heard in the tort action and what was heard in the contract action, and decisions that are rendered in the tort action, there will be an appeal taken from those damages issues, would affect what is going to happen.
Yeah, but on this issue involves the contractual claims only, and it's an interpretation of the scope of the contract. So why can't this, at least the issue of whether Vargas should have testified or not, be considered at this point in connection with the appeal of the bench trial judgment?
So there is no final judgment because plaintiff still has live tort claims against 20 East, Urban, and TriStar. There is no express severance on the language of the court's decision. There's no implied severance because all of these claims arise out of the same continuum of facts. And there's no party finality here because plaintiff still has all of these claims as against all of the other defendants, and all of the other defendants have their cross claims. Those are the only three exceptions that would allow this appeal to go forward and allow this interlocutory judgment to be used to bring up the motion in limine. This is just simply not a proper vehicle to bring this up. That's the problem.
But you will allow me that that a decision on this will affect only the bench trial concerning the breach of contract. That's the only thing it pertains to.
That is correct, but again, it's not been impliedly severed because it arises out of the same continuum.
No, I understand that there's overlapping, but and I understand for whatever reason the parties charted their course, which is an interesting course, I guess, and we're limited by that. We'll abide by that. But all right. We understand that point, though. All right. Anything else? Any other further point that you want to make?
Proceeding on to Justice Oring's point about this sounds like a motion for summary judgment. It really is. Vargas's testimony is improper as it relates to the indemnification claim. Indemnification requires that the loss be incurred. No loss has been incurred, and the incurred loss would happen when the sale of the property happened. He has not sold the house.
That goes back to my earlier point when I said that the plaintiff did you a favor by not selling the building outright after it got damaged, because then it would have locked in their loss, and then you would have lost that argument in front of me right now.
But the flip side of that coin is that Vargas is setting them up for a windfall. Assume that you use Vargas's methodology and he gets
windfall, like Justice Kaplan says, a windfall here. That's kind of like that's kind of relative here, given
well,
that.
I mean, you get to put on testimony. You get to put on your own expert. You certainly get to cross-examine the witness, the expert witness. It's not like he just gets to say it and the judge buys it. Lock, stock, and barrel. I mean, that's not how it goes.
The windfall arises in this case because they're still holding on to the property. Assume that they're awarded this $11 million. They hold on to the property, and then the market appreciates like it tends to happen in New York. They've now been made whole with the $11 million, hold on to the property and sell it for a profit. That's a windfall. That's not.
Okay. All right. Let's hear from the plaintiff. You have 2 minutes, and I'm going to hold you to your 2 minutes.
So many issues, so little time.
There are a lot of issues, and you're not going to get to them all in oral argument. And we understand how complicated the case is. Honestly, we do. So you have your 2 minutes. Go right ahead.
I'm going to focus. Number one, Mr. Leiter described a series of facts which happen to be untrue, but I don't even have to go there because, as Justice Oing said, that's what a trial is for. So these facts, like how they were going to sell the house or why they were going to sell, first of all, he's wrong, but it doesn't matter because almost every single issue in this case on this appeal is a factual issue, which should be decided at trial, not on oral argument. Another example, he said we didn't put it in our in our bill of particulars. Our bill of particulars, we specifically put it in our bill of particulars, the market loss damages in our first bill of particulars 3 years before trial. He's just misrepresenting the record. And also, I'm shocked that we're still talking about interlocutory judgment when we expressly waived in our appellate papers here before your honors any judgment on the jury trial. We don't want the jury trial. The 20 East had agreed, and this goes to their cross appeal, they agreed 3 times on the record, 3 times on the record that the judge's decision would be independent, that the plaintiffs get the higher of the two, and that the jury could rationally come up with $1 million, but I might think the evidence supports $7 million, to which their counsel responded, Your Honor's decision would be independent.
So one quick question, just so that I understand this procedurally. You're not going to enter a judgment on the jury?
Absolutely not.
All right, and what about the collateral source hearing? What's the story?
They just made that up. There are no collateral sources. They were thinking that we were going to double recover on the jury and the non-jury awards, but we were never going for the jury award.
So
and there are no
the jury
collateral
award,
sources.
the jury trial is kind of like null and void. I mean, it was like almost a waste of time. I guess maybe not.
That raises an issue as to how this was handled to begin with. What you had was a contractual waiver of jury in the license.
I saw that.
Right, and then nobody wanted to waive. Both sides, neither one wanted to waive the jury voluntarily on the tort claims. So you had this mess. But still, I'm sorry, but I just want, first of all, Justice Gish, in 881, you can't get an underpinning because that's a permanent incursion. They had to underpin our property.
Fair enough. Fair enough.
It was not even available in an 881.
All I'm saying is that the idea that they're making like that the license that was given was this beneficial commercial contract was such a big deal, and your point is it was not.
It was not. It was a one-way.
In a way, it's irrelevant. So I don't want you to get waylaid in that either. So
okay, but I have one last point, and that's your speculation point. Let's not forget, the reason this house hasn't been sold is because 20 East breach of contract has prevented the sale. Sure, we could sell it for $5 million, but who would do that? We can't sell it for anything close to market while there's $6 million of damage to the house. That's a continuing breach today. And even though the judgment has already been entered, and by the way, the law is that an in limine order is appealable by itself after judgment is entered in the trial, and there's no question that was done here. So there's just so many issues. I think that if you keep in mind the fact that this was a one-way agreement and that they were just being good neighbors, and they let these people do whatever they wanted, this crazy stuff on East 64th between 5th and Madison, and all they want is an opportunity. They just want their day in court to prove their loss. That's all they want.
Okay.
Thank you, Your Honors.
All right, and we're going to hear from 20 East 64th. Your last 2 minutes, Ms. Duretsky.
All right, thank you, Your Honor. Quickly, to address this collateral source hearing, it's not just a term that's made up. This appeal was perfected by plaintiffs while the post-trial motions were still pending before the trial court.
No. It's you missed the point of my question to your adversary, which is a collateral source hearing going forward?
It's going forward at the end of this month, and there's briefing due on it at the end of this week on Friday, March 19th. And the purpose of the hearing is for the court to finally address this issue of duplicative damages awards for repair costs, and the alternative living expenses decided first in the jury trial where TriStar and Urban.
Counsel, you don't agree with the plaintiff then that you've agreed to take the higher of the two amounts?
There was certainly never any waiver by 20 East that the bench trial court could redecide those precise issues of damages that were already decided in the jury trial. There was a stipulation
to agree to take the higher. How could you have higher if there aren't two venues deciding it?
The bench trial, the stipulation to bifurcate the phase one part of this damages trial was so that the Judge Cohen could decide the breach of contract issues solely between plaintiff and 20 East. So we didn't get to discuss it today, but that would include the inter-party indemnification.
You had experts testifying about damages too.
That was part of, because 20 East participated in both trials, in the jury trial and the bench
So
trial.
how can you say that the judge on the bench trial was not allowed to make a decision on damages? It's mind-boggling.
Well, he absolutely was, and the stipulation for the bifurcation there permitted him to make a damages decision on the breach of contract claims. The strict liability and negligence claims were before the jury because they involved TriStar and Urban as well.
I thought the plaintiff just represented before us that he's never planning to enter a judgment on the jury trial. He's going to forget about that. So what are you fighting about all that on the jury trial if the plaintiff's not going to ever enter a judgment? He entered a judgment in this case. On the damages case, I have the judgment in front of me. That's what, that's what we've got. So why the heck, if he's not going to enter a judgment on the jury trial, we're talking about the jury trial? I mean, I still can't understand this.
I can answer that, I believe, Your Honor. It's because TriStar and Urban maintain that they are not subject to the damages award that came down in the bench trial for repair costs and ale, that they need to enter a judgment from the jury verdict, not the bench trial verdict. So while plaintiffs say he's going to ignore the jury trial verdict and make a final judgment out of the bench trial, the other defendants don't agree with that.
So, counsel, you make a very interesting point that while that may be true, that the judgment entered here is on the bench trial, that was against 20 East, correct?
Yes,
on
only 20 East.
So guess what 20 East is going to do? They're going to go after TriStar and the other company for indemnification. They got paid.
Yeah, which is why they're before us now.
Right. So that's why. So this whole collateral source argument that's being raised about the jury trial, that's just sort of a side issue at this point, because the main focus right now is the judgment that has been entered, and that judgment is from the bench trial. So regardless of whether or not the other two entities are part of that or party to that, that doesn't matter, because the plaintiffs right now have a judgment against 20 East, which means if they finally at some point collect on that judgment against 20 East is going to turn right around and go after the two other companies, which is TriStar and I forget the other company's name, Urban, to be made whole. So that's where we're going with this. I mean, it's a very simple to connect the dots.
Right. I see where we're going with this, but we would still maintain that it's not a final judgment right now because there's no party finality. And plaintiffs even said in their opposition to TriStar's motion to dismiss that TriStar and Urban have no interest in any of these issues that are briefed before the court in this particular appeal.
Why hasn't TriStar and Urban entered the judgment in the jury trial?
Because we're waiting on this hearing at the end of the month, where they're going to argue that the damages that the jury decided pertain to them.
Okay, thank you all.
Thank you, Your Honors.
Thank you all, attorneys. This is complicated. I'm not sure it isn't complicated because of the road that you folks agreed to, but it is complicated. Thank you.
Thank you.
Okay, final case of the day, South Shore Delights versus Berman.
Good afternoon, Your Honor. Brett Berman on behalf of First Class Products.
I'm sorry.
Yeah.
I meant First Class.
That's why I hesitated, Judge.
Mr. Berman, I am sorry.
That's why I hesitated for a minute.
I hear legit.
Okay. Well, again, thank you guys for all your patience. I don't think this will be as long as the last one, but I do find
it won't be.
No, definitely. no doubt about
right,
it. But
Judge Gish?
Right. Absolutely right.
Well, we do appreciate.
Well, I have to give him an extra minute because I didn't know his name.
Well, you got my name right. It was just I thought I was all of a sudden a client in the case, so it confused me for a second.
Although we have to be very careful as to how we make these arguments because of the privileged nature of the document we're talking about. Correct?
Exactly. Exactly, Justice Owens. So.
It shall not be named.
Right, but thankfully it was not. No one involved here was at Fox Rothschild or myself. So, but this case is equally as important as many of the other cases you've heard today, and I want to just get right to the heart of it. Why? The why is because if Your Honors are to uphold that this email should be produced in response to the crime fraud exception, I want to be very clear. You will all be upending the privilege laws in the First Department. Without a doubt. And the reason for that is pretty clear. And Your Honors know from the Stock v. Schneider-Harrison case, which really dictates the premise that we're operating under here. A party seeking to invoke the crime fraud exception to the attorney-client privilege, quote, must demonstrate that there is a factual basis for a showing of probable cause to believe that a fraud or crime has been committed and that the communication in question were in furtherance of the fraud or crime. So it's a two-part test. And the law is very clear in New York, and this is really what's wrong with the analysis that was done with the trial court here. Well, there was no analysis done by the trial court, but what is wrong in the decision of the trial court is that the only, quote, evidence that was before the trial court of this alleged fraud, forgetting even getting to the second part of the test, is the deposition testimony of various members of the plaintiff class. And that, we cite this in our reply brief, but I think it's particularly telling.
I gotta take issue with that. What about Mr. Corsover? Corsover, all his emails seem to say that there was some markup on the price of ice cream. And so that was something that was nefarious that the defendants were doing. And so he's a non-party.
Yeah, well, again, that is really a red herring, respectfully, Judge, because that's actually not what he's talking about. He's not talking about the agreement. He's not talking about the pricing. He's not talking about the proposals that were made by the plaintiff's rep. So again, that was thrown in there cleverly, quite frankly, by opposing counsel, but has nothing to do with the issue of what we're talking about here. The only actual allegations of fraud in this case, or the only actual allegations that could ever rise to any level to, quote, support this in furtherance of a fraud, is what we cite on page 3 of our reply brief, which is the testimony of Robin Garman, the principal of the plaintiff, the testimony of Nina Schurz, the of the plaintiff, the testimony of Jonathan Schurz, the principal of the plaintiff.
Counsel, I'm sorry to interrupt you. Let me just quote you a chapter and verse from Mr. Corsover. All right. So he asked the question, he pointed this out to the appellate, to your clients, I believe. If the supplier is first class, no problem. If the supplier is the dairy, how would that account for your markup? So
yeah, sure.
It's out there.
Well,
there was this markup.
Yeah,
it's going to be disclosed or not is the elephant in the room.
Well, the elephant in the room is actually what was in the agreement that we're talking about here, where the language at issue that we're talking about was in fact proposed by the plaintiff, right? So if you're going to say that the in furtherance of a fraud was the language that was proposed by the plaintiff, the only support here of what we're talking about is the plaintiff saying that there was a fraud. And respectfully, just imagine what happens in privilege law as what we're talking about from what the trial court did here with absolutely no evidence of a fraud. You would just simply say any plaintiff could file a fraud claim and then say, I was told something pre-deal and make it a fraud. And that's the support to then breach the attorney-client privilege, the most sacrosanct privilege that any of us have to live by as lawyers with attorneys and clients. That's all a plaintiff would need to do by this analysis here. So part one, to your point, that's not evidence of anything. It's surely not evidence of language that was proposed by the plaintiff here, right? That's who proposed this in a fully integrated document for an agreement that was negotiated by counsel for both sides. I mean, that's what we're talking about here. So when you look at what's before us, the first part of the test can never be supported under the law by the testimony of the people who are alleging the fraud, because otherwise privilege would never exist in a fraud case under any circumstance. But even if you go further, even if you go into the Corsover emails, you have nothing in the face of the email that was produced to say that the lawyer here, who again, to Justice Oing's point, was not Fox Rothschild and was not the lawyer on this call, but the lawyer here was, if you look at the actual email, which is what the judge would have to do at the trial court to say, was it done in furtherance of a fraud? That's the second part of the test here. Look at the email.
But the trial court did that. We told them, you need to look at the document. So the document was looked at in camera.
Yep.
Now what?
And let's look at the email, right? So if that's what the trial court is supposed to do, they have to actually look at the email, not only talk about the first part, we're now in the second part. And let's talk about the email, because remember, it's only the unredacted email. I don't remember respectfully which copy you guys have, but what's been produced and ordered to be produced has none of the writings of the lawyer. And
but otherwise, the typed-in provision was to be produced.
the typed-in provision, exactly. So I'm only talking about the typed-in provision right now, and I just didn't know which copy.
It hasn't been produced yet, right?
It has been produced. It has been produced.
It has been produced?
Wow.
It has been produced per the court order. We don't have a stay, so we had to produce.
Stay. Okay.
We had to produce this email, but again, that's only part of the problem here, right? The actual email, because we can go to the actual email, which is what I was about to say to all of you guys.
Okay.
When you oh, I'm sorry. Were you saying something?
Just if you're right, we can say it's clawed back.
Exactly. No, exactly.
Okay.
I don't think that the horse is not out of the proverbial barn. And again,
I get it.
Right. And it's more harmful, quite frankly, is the trial court opinion, or not really an opinion, but the words that are stated, because of the exact reason that opposing counsel put in their briefs, that now they could use this on summary judgment as some evidence of fraud, right? The judge's words of it, evidence of fraud. And that's why we're here, right? Not because of the email, because I want to.
Probable cause is a different standard than they would have to show that to meet a summary judgment standard. So I don't think you're right. I don't think it has any law of the case or res judicata effect. Probable cause is something different.
And I actually agree with you, and thank you for saying that, for when I could use those words, Judge, in response to their summary judgment motion that they'll file. And I agree respectfully.
We look forward to the
but I agree with you. And quite frankly, I want to go to the email for a second and not spend a lot of time. And it's only because it's not about the email that I'm here, judges, because the email on its face is nothing. It's a document being sent from a lawyer to a client saying, look at the agreement. So that's why I want to focus on the email, not that there's anything harmful and not that the horse can't be put back in the barn, but the trial court was required to look at the email and ask the second part. Was this email sent as part of a furtherance of a fraud? That's the test.
Are you saying, by the courts having found that it was, that in fact the court is also finding that there was a fraud? Is that what you're saying?
Well, I think that's what I think opposing counsel tried to argue in their papers. I don't think that's true, by the way, and I don't think there's any preclusive effect. But I'm just yes. That's the problem here,
that's your
right?
concern, I guess I should say.
That's why we're here, not because of the email.
Got it.
But we're actually here for the bigger issue that I started with, quite frankly, which is the troubling nature as a lawyer who's representing a client who if you affirm this type of finding, what you will be saying to all of the lawyers and all of the clients out there is just plead, and you're a plaintiff. Plead a fraud in the case, testify that you were defrauded, that you were told something different than the agreement says, and all of a sudden a trial court judge can say, turn over all of your privileged communications because I believe that these emails were sent in furtherance of the fraud accepted by what the plaintiff testified to. That's what we have here on this record. And
I'm going to ask you to wrap up, Mr. Berman, because I did let you exceed your time by a lot. That's my modus operandi tonight.
No problem.
Okay.
All I will say is I beg of this court to not eviscerate the attorney-client privilege in the First Department in this manner.
Mr. Berman, one last question, Justice Gish.
Sure,
the complicating factor here is that the prior order from this court was remanding it back to Supreme Court to do an in-camera review, because I think originally, Supreme Court agreed with you and said, don't turn over the document.
No, it's actually reversed, Judge. And you were on the last panel, right? So you were there. You were one of the judges with, I don't remember if anyone else was.
Yeah.
But no, it was actually opposite.
It was turned over everything, and we said no.
The judge, and I won't say who it is because they happen to be on the appellate court now. That judge said that without looking at the document in camera, turn it over. Right, and so you send it back and say.
That's when we reversed and said, okay, thank you.
Yes.
Okay. All right, let's hear from Mr. Morris.
Thank you, Your Honors. And I'm going to start where Mr. Berman did, which is just looking at the test, whether or not there is a factual basis for showing a probable cause to believe that a fraud's been committed. And as Your Honor pointed out, the part of this test is not whether it's beyond a reasonable doubt. It's not clear and convincing. It's not preponderance of the evidence. It's probable cause. So my clients obviously contend that the markup was a fraud. And what's in this record that provides a factual basis for a showing of probable cause that the markup was a fraud? We can start at record page 72. There's a contemporaneous email from my client to her own attorney at the time, an email she sent before she signed the contract, where she tells her own attorney there would be no markup. And second, if you look at the license agreements themselves at record page 83 and 134, both with the identical language about the price from the supplier, but with the price to first class being $850 and the price to my client being $1350, which bakes in the undisclosed markup. And then third, as Justice Moulton pointed out, there's the emails from DEI, the ice cream supplier, asking the defendants, hey, why don't you just disclose your markup? Why don't you add in the fact that the company has the right to upcharge? So if you look at this in the totality, and I'm not even asking Your Honor to look at, or Your Honors, to rely on my client's deposition transcripts, but if you look at this other evidence in the record and you ask yourself, well, is there a factual basis for showing a probable cause to believe the markup was a fraud? The answer is yes. And so once you determine there's a factual basis for finding a probable cause, we move to the next step of the test, which Mr. Berman pointed out, whether this communication was in furtherance of the fraud. And here, the trial court got this right. You've got the client, an email from my client at record page 117, paragraph 3, where Ms. Garman is asking about the Exhibit C, which was dropped into the agreement by Jill Beer, the attorney from Greenland. And then this email is forwarded, and in the withheld email, Ms. Beer reassures her client that it's his business decision for them to consider what price they want to put in Exhibit C. So Ms. Beer is essentially saying it is your business decision about how much of an undisclosed markup you want to bake in. So there is more than probable cause to believe that the markup was a fraud, as the trial courts properly found, and this communication was in furtherance of that fraud. The trial court simply got it right. And I'll open it to questions if the court has any.
Any questions, colleagues? Okay, Mr. Berman, 2 more minutes, that's it.
Yes, I want to go back to Justice Moulton's point, which was regarding the crossover email, because I don't think I answered him fully before. And again, what I said before, which is, and I want to reiterate it, the crossover email does nothing to suggest that appellants told respondents they would pay the same price for the ice cream. It's actually proof of nothing, right? So you don't have anything in the actual agreement that's fully integrated that's proof of a fraud. You don't have anything in an email that's proof of a fraud. The only proof of a fraud in this entire case is the 4 testimony sets from the plaintiffs. And again, I urge the court to strongly look at this issue, because we should all be hesitant to have this type of law created in the First Department, where you can simply have deposition testimony from a plaintiff and then support that to claim there was a crime fraud exception to the attorney-client privilege. That is a very slippery slope that I think judges and lawyers should be very careful about opening up our most sacred privilege that we share with our clients to try to facilitate legal advice.
You're talking about a parade of horribles that I don't know if will occur or not. I mean, we're being very, if we uphold the lower court, or even if we pare down what the lower court did, it's still a very small portion of all the email traffic, I'm sure, that went back and forth between the lawyer and his client.
This was actually, Judge, I took over this case from the second set of lawyers, so we weren't involved in any tier, but actually this was, as Mr. Morris put in, the only email that was attorney-client privilege that was withheld on the privilege log. This is it. And again, I want to be clear, because I said it before, this is not about the actual email per se, because that is, again, it's not so important. I don't think there's anything in that email that's harmful. It is about the destruction of the attorney-client privilege based on testimony of a plaintiff to support a fraud. That is a very slippery slope that this court should be very careful of opening, because there's not a lot of law on this subject, quite frankly. And this court may well create law that all lawyers in the First Department look to about whether or not a plaintiff can pierce our most sacrosanct privilege by simply alleging a fraud by their own testimony. That is contrary to any law. I can't hear you, Justice Owing. I think you're on mute, maybe. If you,
Yes.
I think my wife would say the matrimonial privilege is the most sacrosanct.
Yeah, but Mr. Berman, Mr. Berman, I just taking from your last point there about how, it's more of this appeal is more of a substantive, not so much this email that you're concerned about, but the overall directive that we're going to be going, or at least issuing, if we don't agree with you. My thing is that my concern is that, that would be, we're giving broad strokes to a principle that we don't have. You're asking us to give paint broadly in terms of, whether or not we have attorney-client privilege documents should be turned over. And I'm not so sure that, that like Justice Moulton says, I'm not so sure, I agree with him, that we can make that sort of broad, those broad statements without,
Yeah.
we call balls and strikes,
Of course. Of course. And I don't mean to say that you're going to change the law. My point is that in the analysis that was done here, it's a two-part test.
Okay.
Reaffirm what the two-part test is so that everybody in the first department knows exactly how you could get to a crime fraud exception. And quite frankly, it's as I said, the turning over of this type of email is troubling. The lack of the analysis with respect to both parts of the test is troubling. And quite frankly, the lack of law in the first department with respect to what the trial court should do when looking as to whether or not the crime fraud exception applies is troubling, because it allows a trial court judge to really just say crime fraud exception applies, no analysis of how, why, where, or when. That was my point, Justice Ong and Justice Moulton.
All right.
Okay. Thank you. Thank you all.
Thank you, Your Honors.
This session of the Appellate Division is now closed.
Thank you.